On the other side, I beg to mention item 47. And for the respondents, all the respondents. 47.
Why you wanted time?
Well, I need to file my affidavit in opposition. I need some further time for that. PB
Respondent number 1 to 6.
1 to 6. What?
Learned
Interim is an interim order.
interim.
Yes.
Item number 47.
47.
Learned counsel for the respondent number 1 to 6 praise for and is granted
3 weeks time.
3 weeks time to file affidavit of opposition. Interim order pass earlier shall continue till the next date of listing.
May I please?
Yes.
With consent of the other side, I beg to mention item number 3.
Item number
3. During this case, we have filed an impeachment petition as well as connected another petition pertain to the last previous petitioner. Matter may be fixed on 28 along with other.
matter should be fixed to it.
We have filed in petition yesterday connected petition. The WBC 227620.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed
28.
on 28th. Nothing is there.
Another matter may be listed, connected matter.
We are not saying anything. You make that mention.
Therefore, listing this matter located on 28.
Well, let us decide it, then that will be also decided.
No, we have already filed. No, my lord. Actually, what happened, my lord, we have already filed, my lord.
You have
Yes.
already filed,
Filed, my lord.
numbered, not yet
Serial
listed.
number it is been given.
So therefore, how can we make a connect this with this?
No, my lord. Let it be listed on Wednesday, my lord. Urgency is there, my lord.
No, this matter we have allowed to be listed on Wednesday.
Wednesday,
No
that-
problem on that.
But another phase.
So give us the mention memo then,
Yes, yes.
or then we will allow listed
Lord.
on Wednesday. That is not a problem.
Lordship.
I thought to pass an order
No, no.
along with this. No,
No, no.
that is that we are allowed.
Lordship.
This is item number 3.
See, my.
Okay.
Yeah, please,
Yes.
my lord, I am for the respondent, I will responded, my lord.
Hmm.
This petition may be listed for 28
What is the matter about?
matter related to the settlement of T-Shari.
When notice was issued?
In the month of June, my,
What is the next date fixed?
there is no, the 4 weeks, they are enjoying the
Okay.
interim.
Okay.
Most possible.
Yes.
Kindly, I can.
Lordship, WPC 1498.
Yesterday's
My
matter.
lord,
I have been
Not
give a-
listed,
give a mention memo.
my lord.
Hmm.
Back to my,
Most possible.
Inform Mr. Nath.
my lord.
Most possible.
Yes.
My lord, kindly, item 13. my lord. I file yesterday affidavit. my lord. And
Item?
I want to bring affidavit. Item 13.
Okay.
Deputy.
May I please, Lord? Thanks for listing. Matter was listed wrongly in the on 21, Lord.
Hmm.
Matter was.
Make a mention on Monday. Okay? Make a mention on Monday.
May I please, Lord?
Yes.
Lordship, with regard to item number 41. 41.
Yes.
My senior, Mr. K.K. Mahanto, is having a personal difficulty. I've taken the consent of other side also.
But I am appearing for the respondent number 2, 3, 4, and 5. Will like to file an affidavit today.
You are for
I'm for respondent 2, 3, 4, and 5.
learned counsel for the respondent number 2, 3, 4, and 5 praise for and is granted.
Today will file.
Submits that an affidavit is being filed during the course of the day. Accordingly, a prayer for adjournment is made. First, prayer is allowed. List this matter.
Lordship, on 5th of March,
On 5th of March.
oblige, Lord.
My lord, I take mention for listing in motion, my lord. My lord, filed in 9 to 2020.
What is the issue?
Issue, my lord, regarding contractual field, my lord. Work has already been completed, my lord. Bill was
That will
submitted.
come. What is the urgency?
It is-
That will come. Yes.
May I please, Your Lordship, I beg to mention item 32 to 34 of today's list.
30.
2 to 34. Lordship, here I'm appearing for the BTC. Lordship, 4 weeks time is required to file the affidavit. We have informed the other side.
Okay, there is a stay.
Yes, Lord. The interim is in the favor of the petition.
Okay. Learned counsel for the respondent BTC. Press for
4 weeks time.
4 weeks time to file affidavit in opposition. Prayer is allowed. The interim order pass earlier shall continue until further orders.
Good morning, Lordship.
Hmm.
Lordship, I want to pray for urgent listing of my case.
my writ petition filed on appointment in compassionate ground.
Appointment of, this is not a bench for appointment in compensation ground. You'll have to make a mention before bench street court number 2. Or in this court on Monday. Relates to which department?
Government bank.
Government?
Bank.
Bank. So you will have to make a mention. If you make a mention today before court number 2, and if you make a mention on Monday before this court. Okay, next.
Lordship, my matter is listed in supplementary cause list 52,
Yes.
but another matter writ appeal also listed in court number 1 today. So my prayer is that if my matters can be heard after second half, otherwise both the matter, writ appeal as well as this matter will make clash.
Your matter is non-payment of contractual bills.
Yes.
Is not it?
Yes.
We'll issue a notice. Whether you are present or not present, we are not going to determine anything today.
But-
Is not it?
But
Are you going to make, okay, I'll give that item.
item number 52, but it's serious matter.
No, it's not serious matter. Your allegation is that, your allegation is that they are, because you have filed cases, they are not forwarding your bills and all. Is not it?
Yeah.
So your allegation is serious, matter is not serious. Is not it?
But I
And,
will
and
accept
we'll have to need, hear them also. Is that it? So, you notice, hard.
but matter
Mr.
should be, I noticed to be early because after March will court close and I will not get the payment. Within 7 days, then.
Hard, hard, Mr. You are Mr.
PK Bhattacharya,
P.K. Bhattacharya, learned counsel for
learned petition in person.
petitioner is sponsor or person. The present application is filed for non-payment of so issue notice, returnable on, give a date,
I will sort it.
after 31st must give a date. No,
After,
no, before that.
after 31st March, financially every close.
There is no guarantee that before financial year you will
Yes,
get
yes,
it.
yes.
And there is no necessity of having
Yes, Lord, I got it.
for this court.
Got it.
Okay. 21st of March, 2024. Who will accept notice? Huh? Standing counsel, Upadhyay.
Upadhyay.
And Upadhyay, learned counsel, accepts notice for all the respondents. Okay? Extra copies, you will have to give extra copies to N. Upadhyay. Please take. Yes. Yeah, because it amount heritage. Yes.
Lordship, this competition filed, my lord, not complied the order, my lord. It is, my lord, next 4, my lord, page 28, my lord.
What about the repetition?
My lord, it is still pending, my lord.
We'll list this matter next week along with the repetition. Okay? At a motion. List this matter on, give a date.
My lord, repetition now, administration.
Okay, let the repetition come in the motion stage itself. Then the other side will appear. Then we can obtain instruction what is the actual situation. Why should we issue a notice if they have violated? Is that it? Let us see. Next week, any date? List this matter on 6th of March along with WPC
5870.
5870 2020 in the motion column. Let us see on that day.
May I please your lordship, instruction not received.
Lord, may I pray, Lord?
Hmm.
Can be disposed of in view of the Lord considerably. Lord, may kindly see the last page of my petition.
Now I have seen that and there is the court has also raised a doubt on the,
Later,
we do not know.
Mal.
Court has raised a doubt. So therefore, let them come
Yes,
and
yes.
file an affidavit and say that yes, we have issued this. That's all.
My lord may keep on the motion state.
No. Heard Mr. A.R. Bhuya, learned counsel for the petitioner. Contractual bill 1997 626. Okay. Who will accept notice?
M. Duff, my lord, PW. M. Duff.
M. Das, PWD. Accept notice on variable. Okay, next date.
Sir,
They will
but,
obtain
may I
instruction.
pray on the next week of March, after 43.
As if everything can be disposed of before 31st of March, and as if everybody is getting money before 31st of March.
My prayer only.
Prayer stands rejected.
Replace.
Obliged.
Right, my lord, we have filed, my lord, the additional affidavit, my lord, today itself, my lord. This is not on record, my lord. So can it be processed, my lord, in the next week, my lord, so that.
Mr. Mondal, tell us. Forget about your additional affidavit for a time being. What is your prayer?
Now,
What is the dispute and what is your prayer?
now prayer, my lord, lordship, my lord, kindly see at page, my lord.
No, no, we'll not see. Tell us.
Yes.
We'll believe everything.
Now the, my lord, two authorities, my lord, has issued the, my lord, impugned order.
Hmm.
One is, my lord, Panchayat,
Hmm.
and one is, my lord, the.
What is the end result of the impugned order? What they say?
Now, two authority has settled the, my lord, state Pargat
Hmm.
to the two individuals, my lord, that's number
Okay.
14 and 50.
Hmm.
Now, we are the, my lord, patta holder.
Hmm.
Now, in view of the, my lord, the decision
So,
held by the honorable court,
Hmm.
the, my lord, the respondent number 14 and 15 cannot be, my lord, settled.
Where is that order?
Yes, sir. My lord,
Order of this court?
yes. My lord, Rupam Talukdar, my lord,
Hmm?
2009 4 GLT.
Hmm?
Rupam Talukdar, my lord,
Okay.
reported in, my lord,
What is the
2009.
determination here?
Here, my lord, the section 5
Hmm.
and 47
Hmm.
has been declared, my lord, ultra bias.
What section 45 and 50 says?
My lord, 107 lordship will find.
This?
My lord, paragraph 18
Of which judgment?
of, my lord,
2010?
Rupam Talukdar,
Okay. Paragraph?
paragraph 18.
Okay, fine. Now, where is your tender?
Tender lordship will find at page, my lord, 19.
Page
19.
919.
19. And
Okay.
particular, my lord, page 20.
19. Which was the market here?
My lord, Suapata part 3,
Suapathar part 3.
Katakaligat.
Okay. So, where is the area of the market?
This is, my lord, Parghat, my lord.
Where is the area?
Yes. Now, as per the report of the circle officer, lordship will find at page 17.
Page 17.
Page 17.
Hmm.
It has
Now,
been said, my lord,
situated at Dag number 316 and 317.
my lord,
317 belongs to you,
petition.
petitioner. Now, they want to run a market.
Correct.
Okay. Now, what this court will decide? That this 317 belongs to you.
Yes.
And they have no right to run a market over this land.
Right.
This is a job of writ court.
Now, this is held by the honorable court.
Huh?
This is held by the
The-
honorable court.
Honorable, this court bench court held that market cannot be, private market cannot be interfered.
Yes.
Or something like that. Now, how this section 107, so therefore in a case, you'll have to determine whether that is your land or land belong to the.
Now,
Uh,
report, page 17 is the report.
How,
of the
yes,
circle officer.
fine.
Yes.
Now, before that, is it not necessary to determine that this 3017 belongs to you?
Yes, that's that.
Who will decide that?
That my lordship may issue notice to the respondent authority.
No, is it a job of a read court?
Now, since it is-
See, somebody is running and running a is trying to run a market over your plot of land. This is your case. Or settle a pargat over a plot of land, which is 317.
Yes.
Okay. Now your case is that this land belongs to me.
Yes.
How can you run a market over my land? Now, how the read court will decide that this 370 belongs to you? What is necessary for that?
now, lot of
What is
our-
necessary for that?
Yes, now.
Your
lot-
title deed, your mutation order, and it is to be proved
Yes.
that yes, this land belongs to you.
That is why, my lord,
Is
we
it
have-
not a subject matter of civil suit?
now, once this honorable court has decided, the my lord issue saying that the section 107 is ultra wire.
Okay, what is the
Now-
section 107 says? Tell us.
The import notice, lordship will find at page.
What section 107 says? Earlier provision.
My lord,
Read that.
settlements of private ghat and fisheries.
Hmm.
By the Gaupancha.
Hmm.
The powers of the settlement of the private ghat fisheries under the jurisdiction of the Gaupancha shall be vested in the standing committee as per subsection 1
Hmm.
E of section 2022.
So, Panchayat is not having power to settle private ghats. Is it your case that this is a private ghat?
Yes, definitely private
You-
ghat.
Your your case is that this land is under 317
Yes,
and they have given notice of this 317.
my lord.
Now, we'll have to determine first that whether that 317 belongs to you
Yes,
or anything to show that a ghat has been run over 317 by you. Where is that?
that is the report, my lord, page 17, lord. From the circle officer. my lord. May I read this, my lord?
Yes, read it.
My lord, then, in the subject cited above, as per the report of the Latmundal, it is seen that the Suapata Part 3 Katakali Ghat under Kazaikata Suapata GP is situated in the number 316 and 317. The Pattadas of Meri Patta number 242, the number 316, land measuring so and so, Johir Ali, Mohiruddin, Samiruddin, Moyazuddin, son of so and Pattadar of land measuring 1 biga 4 kata 13 lesser covered by Meri Patta number 152, the number 317 in the sorry, my lord, it should be in the Muhammad Ali, son of Pilat Ali. This is the my lord, position, my lord.
Hmm.
And Kazaikata.
Where is that there is a private ghat is being run by you? This days has also come anyway.
It is stated, my lord, only the
That this land belongs to you. You say that this land belongs to me, so therefore government has encroached and trying to have a market.
my lord.
Now we'll have to decide whether that land belongs to you in a read proceeding. That is your proposition.
Now, my lord, if notice is issued, my lord, the other side will, my lord, counter.
Hmm.
If they say this is not, this ghat is not in the, my lord, said particular land, then we have no case. My lord. Is there, my lord? So, my lord, my humble, my lord, prayer, my lord, let notice be issued, my lord.
No, you are not
can
issuing a notice here. What affidavit you have filed?
Additional affidavit, my lord, filed today itself. Showing the, my lord, the Jawabandi copy and my lord, land holding certificate and as well as my lord, revenue receipt.
That days has now come. We'll close the civil courts. Have a box here. And a prayer of the learned counsel for the petitioner matter stands adjourned and be listed in the next.
In fact, my lord, IWT is a necessary party, my lord. So they have made party, but copy not sir. That is why a name not showing.
I can.
Yes.
We'll serve copy, my lord.
If the learned counsel for the petitioner submits that a copy of the petition shall be served upon the
See, it is for their IWT.
standing council, IWT. Registry to
Reflect the number.
reflect the name of standing council IW2
below.
in the cause list.
Madam.
Oblige.
May I please? In this case, my lord, in the similar case, my lord, lordship.
Mr. Gogoi, you have raised an objection as regards maintainability. But these people cannot be remediless. You yourself has
No, it is there, Lordship.
Huh?
A provision is there, Lordship, as per 29.
provision is to file appeal before whom?
Before, Lordship,
To
now.
a divisional commissioner,
No, divisional, now it should be secretary, Lordship.
to the secretary.
Secretary.
New thing is it?
New.
Okay.
No, my lord, new, my lord, they have not, my lord.
No, okay, okay. We have kept that open.
Lord,
Okay.
Lord,
That notice.
Lord.
When the order was passed?
After, my lord.
No, no.
before,
Day before yesterday, it was.
I told you, na? Yes, okay. Day before yesterday.
yes,
Okay, this item then
eight,
Eight also
13,
8 others ke go, 8,
13,
13, 14, 15.
15 minutes.
Okay.
Lord.
8, 13, 14, 15. JMH Chaudhary.
Sure.
And we'll decide all these
Lots,
matters
yeah,
on the
lots.
next day.
Lordship.
Because unnecessary keeping pending
Lordship,
in a
Lordship.
writ proceeding
Lordship,
will stays at admission session.
Lordship may fix it.
In other cases, we have not fixed it.
No, not fix it. This may come along with the other. 894.
You do one thing, make a mention next,
Look.
after we are issuing a notice for 4 weeks.
Lord.
Thereafter, make a mention,
Look.
when after returnable date.
Lordship.
13, 14, 15. Huh? Yes, Mr. JMH Chaudhary, what about item number 19?
90.
Not, okay. 8.
Item 6.
Which department? Who appear for whom? Tell us. M.I. Hussain for petitioner and
MDAS for PWD.
MDAS for
PWD.
PWD and revenue. Respondent number 2, standing council revenue, and for respondent number, Gogoi for respondent number,
4, Lordship.
respondent number 4, GSM. 4 weeks, and they will, in that order, they will obtain instruction whether amount is due, admitted, and if yes, why payment has not been made. Pendency shall not be a bar to make such. Ask already.
I think 7 and 10.
7,
And 10. Similar matters were taken up on 21st. These are related
7, 10.
10.
What was the item number?
Earlier, I have author.
It is also day
21st.
before yesterday. It is also day before yesterday.
Huh?
Day before.
These are relating to the detention camp.
Detention camp,
Where the budgetary provisions exceeded and therefore the final.
7
has
and
been-
10, this order. 7 and 10.
Lordship.
Deeply.
Gogoi, huh? And baki silo. Ready? B Patha and yes, 9 now. Where is the power of deputy commissioner to give you a license?
Subsequently, come to page 25.
Huh?
Page 25.
No, this has been issued to somebody else.
Yes.
But where is the power under the scheme of the act?
So see
Doing
the-
something and having power is
no, no,
different.
The Assam Cattle Preservation Act, section 20.
What that says, read it.
The establishment of an institution, including Goshalas, for
Hmm.
taking care of cattle.
Hmm.
The state government may establish or direct any local authority or permit society registered under.
What is the defined as a state government? State government may establish
Yes.
or direct to whom? Read it.
Or direct any local authority. or
Any local
permit-
authority.
Permit society registered under the society.
So where is the direction to the deputy commissioner that you issue that license to this person?
They have similarly,
No. You are in the courts of law. Deputy commissioner doing something without having power, and on that basis, do you expect the writ court to issue a direction?
Yes, exactly, Lordship, but.
If exactly you are dismissing this,
No,
because you have not approached the government, admittedly, you have approached the deputy commissioner, you have failed to show where is the direction to the deputy commissioner by the state to issue such a license.
Lordship, that fix it better day after tomorrow, I will. Lordship.
Gogoi, what is this deputy commissioner doing? Where is that any delegation of
no.
power under the act?
As per the act, this is not there.
They are not having power.
No.
And any rules framed there under the act?
No.
Now, where is question of pollution, that report from the police, this will give rise,
They make it own laws.
how can they?
On its own laws.
Heard Mr. L.R. Mojumdar,
Yes,
learned,
Is that?
Yeah?
Is that?
Ajed Ahmed, learned counsel for the petitioner. The grievance of the petitioner is that the petitioner had made an application before the deputy commissioner, South Salmara, for granting them permission/license to run a Gosala. Full stop. According to the learned counsel for the petitioner, the petitioners are having right for consideration by the deputy commissioner under the scheme of the act,
Assam Cattle Preservation Act.
Assam Cattle Preservation Act 2021. However,
That's not one, he has already, he passed an order.
however, the deputy commissioner has forwarded their applications to the concerned authorities for report. Till date, no farm license has been granted to them. Full stop. Mr. K. Gogoi, learned counsel representing the state, submits that he need to have instruction whether deputy commissioner is having any power under the scheme of the act, or any general delegation has been issued in terms of section 20 of the act, which empowers only the state government to issue such license and to direct any competent local authority to grant such license. Full stop. Accordingly, matter stands adjourned and we listed
For 2 weeks or
after 2 weeks.
Lordship.
This is the issue.
Lordship,
It
Lordship.
cannot be.
Lordship.
Until and unless you can show that this is the
Yes.
rule frame, under the rule, this competent authority is defined as a deputy commissioner, and these are the procedure having a license, because there is no question of only the state can direct,
Lord.
not the deputy.
He has already given a order. That's
So you are arguing that only.
Yes, but otherwise I have to show.
You propose to
Yes,
say
I
that
agree.
you have a right
Yes,
on the basis of some illegality
No, no.
committed in others' favor.
otherwise I have to show.
You will have to show that this is my right, this is a due process has been followed, but without any rhymes and reasons, they are keeping their application. That's all.
Lordship.
Yes.
Yes, your lordship. Lordship, the petitioner is a doctor.
Hmm?
The petitioner is a doctor.
Hmm.
On being agreed with the imprint order dated 3/10/2020, the petitioner is before your lordship.
Hmm.
Kindly imprint order.
What is the provision of law to allow you to have the sonography? You become to practice sonography and to do sonography.
Page 21 method. Because his provisional permission stipulates that he has to clear a competency-based examination.
Next, competency-based examination. Last, there are 3. If a medical practitioner fails to clear the said competency-based examination after 3 attempts, but this order was issued on 2020.
Hmm.
After 20, only in the year 2021, this competency-based examination was conducted by the department.
Now,
Thereafter,
did-
no examination was held.
Did you participate?
In the year 2021, I did not participate, but 2 attempts
See,
remain.
it says that you can,
And thereafter-
you can be a teacher if you qualify matriculate. Or you qualify for higher secondary. Then, or qualify graduation, but you can practice, you can be a teacher after passing degree. However, those having HSLC and BEd can also be a teacher, subject to condition that you pass the BEd. So therefore, until and unless BEd, you pass the BEd, can you be allowed to do that?
Their case is something different.
Okay, tell us what is the difference.
My lord, here
You are a MBBS doctor.
I am MBBS.
You are not a specialist or radiologist.
I have undergone 6-month course.
Where is that 6 months course?
I have an X.
Where, tell us, show us.
My lord, page 19,
Page 19,
annexure 4. To the type copy.
annexure. Page 19, annexure 4. Okay.
This is to certify that Dr. Abdul Waris, MBBS, Dibrugarh University, has undergone 7 months training in abdominal, pelvic, gynecological, and obstetric ultrasonography at Healthcare Diagnostic Center under my supervision from December 2011 to 2012.
Hmm.
During the period, Mr. Waris has learned under ultrasound.
Is this certificate is being recognized by the health department?
In Mukherjee Lane, Kolkata, it is recognized, my lord.
Huh?
Yes, my lord, page 21, my lord.
Again, my lord, kindly page 21, you can also, my lord, see. If after 3 attempts, if a doctor is unable to complete the competency-based examination, then he cannot be allowed to conduct ultrasonography. Because no examination was held since after 2021. Due to personal difficulties, he was not able to appear in the year 2021.
Now the issue is, yes, Mr. Bora,
Yes, my lord.
rule says
Yes.
existing registered medical practitioner who are conducting ultrasound procedure in genetic clinic or ultrasound clinic or imaging center on the basis of 1 year experience or 6 months training, okay,
Yes,
are
my lord.
exempted from undertaking the said training. Which training? Which said stage? What is the said training? Provided they are able to qualify the competency-based assessment and special schedule. So either 6 months training from or this test. If medical practitioner fails to clear the said competency-based examination after 3 attempts, he shall undertake the complete 6 months training as provided. So if we read as a whole, either 6 months training or competency test, now we will have to answer whether this 6 months training that this person has done
Yes.
is a training as reflected in clause 3. If it is yet, why he need to pass an examination?
No, my lord, because the provisions of rule 6 of Schedule amended provided.
My lord, clause 2 speaks of some other training apart from the 1 year experience and 6 months training, my lord.
No, no, you read the whole. It may be stated that provisions
Yes,
of
my
Rule
lord.
6 of PC, PNDT, prohibition of sex selection, 6 months training. Rule 2014 amended by government of by notification so and so as follows.
Yes.
So this is the amendment. The existing registered practitioner who are conducting ultrasound procedure in generic so and so on the basis of 1 year experience. So there is a permission for those who are having 1 year experience or 6 months training
Are exempted from undertaking the said training.
program. So what is the training program?
That is a different program, my lord.
What is that? Tell us.
No, no, I'm trying to find out the rules because I just got the petition copy now, my lord.
Huh?
We'll see.
Where is the impugn order?
Impugn order at
Impugn order
page
page
22.
22.
Where is your permission?
Permission that
13,
is
10, 20.
1. Page
Huh?
21. Permission page
Page
21.
21. Clarification to perform ultrasonography. Page 21 and etc.
So page 22 says that, my lord, that permission was granted on the condition that he has to qualify the competency-based examination.
But on 3 attempts, my lord. 3 chance, 3 options.
Just a minute. Just a minute. This validity has otherwise gone. 2020
Yes, my
for
lord.
2 years.
Yes, my lord. So in the meantime, he has to qualify this test, my lord. And what just now I have got the instruction that apart from 21, on 27 to 2022, another competency-based examination was held, my lord. So he did not apply and he did not appear.
Only one time, 2021.
No, 27 to
Hard,
2022.
so.
On 27 to
But it is
2022.
Abdul, hard,
My
Mr.
lord, kindly please, Annexer 8, kindly see, my lord.
Annexer?
Annexer 8, page 24.
My lord, Annexer 8, this order is not relevant because that time,
relevant.
my lord,
Annexer 8?
Annexer 8, page 24.
he misled this honorable court by stating that no test was held. So subsequently, I have now got the information. Then 27 to 2022 also.
We are not issuing any interim order because
Yes, my lord.
your permission was for 2 years.
2 years.
Okay? Whether they had held examination or not.
No, it was held, my lord.
Anyway,
Yes.
suppose it was not held. Your grievance ought to have been that please held an examination.
Yeah.
Not that if since you have not held, I will continue.
And he did not apply and he
Heard,
did not appear, my lord.
Mr. You are Mr. ATM Hussain, learned counsel for the petitioner, also heard Mrs. Bora, learned counsel for the respondents. By way of present petition, the petitioner has challenged an order dated 31/10/2023, whereby the petitioner who was allowed to perform sonography, or what do you call it? Who was permitted to perform ultrasonography by a communication dated 13/10/2020 for a period of 2 years, subject to passing out of 6 months training,
Subject to qualifying competency based
subject to qualifying competency test.
based test.
Competency based test. It is an admitted position that the said period of 2 years has in the meantime expired and the petitioner has not qualified in the competency test.
He has not
It is the
participated.
case of the petitioner that no examination has been held during the period. Therefore,
One time held.
that the examination was held only once
2021.
in the
21
year
items.
2021, wherein the petitioner did not participate. Full stop. Issue notice. returnable 4 weeks. Mr. Bora accepts notice for all the respondents.
No, 2, 3 and 4.
2, 3 and 4, who is for 1?
1 and 2, he will,
2, you are 2, 3, 4.
yes, my lord. I am
1 he,
1
Gogoi.
and 5, my lord.
1 and 5 Gogoi.
Okay.
Extra copies 5 days.
May I please your lordship, the matter needs to be withdrawn, lordship.
Why?
Our grievances have already been.
Okay, the learned counsel for the petitioner submits that the grievance of the petitioner has already been redressed. Accordingly, he wants to withdraw this petition. Appeal allowed.
Okay.
Accordingly, the petition stands closed on withdrawal. Huh? Hmm? India. Which department?
Water Resources Department.
Water Resources Department, 3,47,879.
Lordship, this is a work executed under flood management program scheme. And for this, Brahmaputra Board means Ministry of Jal Shakti is a necessary party. Since your Lordship is also aware, it's a state chair and the central chair. They have.
Oh, that matter.
Yes, Lordship. In one of the affidavit, case your Lordship had asked us to file a detailed affidavit regarding that.
Okay, we are issuing a notice. You just bring on notice in the meantime, because it's money, according to them, they had,
We have already given the.
they have, according to them, their share they have paid. You have also been paid part payment. Now there are some proposal to be given to the Jal Shakti. All these are there.
Yes.
We are adjourning it. Give the number to him.
Lordship.
The other case, okay, then you properly implement those parties, okay. The learned counsel for the petitioner seeks for an adjournment. Prayer is allowed.
Okay.
Please this matter after a week.
Okay.
Give the numbers. Then instead of piecemeal, we can take this matter along with those, and these are the amount that will ultimately come from central government.
Yes.
Okay. Yes.
Tender.
Hmm.
On 24 January 2024. That is the page number 25, madam.
Page number,
25.
where is the clause?
Uh,
Offending clause.
Yes, I'm sorry. But then the tender is for hiring security service at Petro University, madam.
Okay, that we understand.
Yes,
But your thing is that there is an offending clause
Yes, madam.
by which you are being
Yes.
excluded. Where is that offending
Yes,
clause?
that and madam.
May I, at the outcome, raise the maintainability issue? Because these petitioners is an association, madam. There is no local standard to challenge this. Because in commercial contract, my lord, it is between the security, because my lord, who is the prospective bidder? He has not approached before this court.
Okay, you take your seat.
No.
We'll address that. Yes.
But after issuing of the first tender notice, madam, we file a representation.
No, which
madam,
is the
madam,
offending clause? Tell us.
Now, madam, at page 60, madam.
Page
60.
yes.
Madam, the technical bid evaluation, madam.
Hmm.
Or if a lordship see at number 1, madam, A, executed single tender value of rupees 10 crore during the last 3 financial year.
You are offended by this.
All of them, madam. Madam, for a work of 1.5 crore, they are asking madam, 100 crore rupees turnover, madam. And this association, madam, there are more than 250 participants in the association, madam.
No, which clause? Clause
My clause 3, madam. Annual turnover of the company
annual
any one
turnover of the
3 years
company
up to rupees 100 crore, madam.
for B 100 to 200 crores.
Yes, madam. Now, what is the violation, madam? I'll show, madam. But kindly see, madam, page not place 73.
Just a minute. Similar action group central. These are the marks only.
Yes, my lord. This is a mark. And my lord, and below my lord, number one, the minimum technical score SC required to be eligible 70 marks, my lord. And no one will be eligible, my lord, in Northeast, my lord, entire Northeast. They are trying to bring a.
Can that
platform
be a
of-
ground to set aside a tender clause?
Yes, my lord. But
High security number plate judgment.
my lord, because my lord, no third party right has been included till now, my lord. They are going to open the tender on 27, my lord.
Have you submitted your bid?
No, my lord, we cannot be submitted. my
What
lord.
was the last date?
But the previous one, that tender was called, my lord, so that has been modified and changed. At this my page 60, my lord.
No. First tender or notice was issued when?
First notice was issued on, my lord,
Hmm.
24 January 2024,
24 January 2024.
my lord.
In the-
Thereafter, we filed a representation
Okay.
before the authority.
What, as per the tender, what was the last date of submission?
As per that tender, my lord, the last date was on,
14 to
14 to, my lord, yes,
14 to
yes, my lord.
2024.
Was the last date for the downloading and opening was on 15 to.
Opening on 15
to.
to 2024. Last date was submission 2024.
My lord.
Now what happened thereafter?
Thereafter, my lord, we filed a representation.
Hmm.
This is at page 45, Annexure 3.
Then what happened?
Then we
Representative
said that-
filed on when?
Hello?
When representation filed?
My filed 28 January, 28.
2/8/1/2024. Then what happened?
Then, my lord, they have again cancelled the previous one and issued the second one on 15 to 2024 at page
15 to
2024.
2024.
4, my lord.
Annex 4.
At that, my lord, the technical bid evaluation has been shown as so and so, my lord.
So now this section D is part of the new tender.
Yes, my lord.
Earlier it was not there.
No, it was there, my lord.
Uh.
They have just said something, my lord. Nothing more than that, my lord.
So meaning there
Both
was
are same, my lord, similar.
both are same.
Similar.
So cancellation is not the your cancellation is not on the basis of your
Yes,
representation.
my lord.
Huh?
No, my lord.
No.
Not done.
So they have cancelled for maybe.
Not done.
Okay.
Whatever.
So in the earlier tender also you were say you had the same grievance. In the new also you had the
Yes,
same
same
grievance.
figure, my lord.
What is the last date under the new one?
On 27, my lord.
27 to 2024.
They are going to open.
They are going to append.
And they have given that you must acquire minimum 70%. 70 marks for out of 100.
Mm.
Now, my lord, what is the final I'll show, my lord? Now,
Mm.
can you see, my lord, page 73, my lord?
Page 73.
Yes, my lord.
Yes.
My lord, this is the office memorandum issued by the Central Vigilance Commission, my lord. Dated 17 December 2002.
Mm.
But the first line says, my subject is pre-qualification criteria. The commission has received complaint regarding discrimination and pre-qualification criteria incorporated in the tender documents by various departments and organizations. It has also been observed during intense examination of various work conducted by students so that the pre-qualification criteria is either not clearly specified or made very stringent or very lax to restrict or facilitate the entry of bidders. Lord,
Hmm.
make to the next page, my lord. Page 73A.
Hmm. Hmm.
Serial number 5, my lord.
Hmm.
The following points must be kept in view while fixing the eligibility criteria. My lord, number 1, average annual financial turnover during the last 3 years, ending 31st March of the previous financial year, should not be at least 30% of the estimate cost. And here, they are sticking 100 crores. And number 2, my lord, experience of having successfully completed similar work during last 7 years. But they are seeking for last 3 years. Ending last day of month previous to the one in which applicants are invited to be either of the following 3 similar works of work costing not less than the amount equal to 40%, madam, of the estimate cost, or 2 similar works costing not less than the amount equal to 50% of the estimate cost, 1 similar work of costing not less than amount equal to 80% of the estimate cost. But these are the clauses, they have to follow their own rule, madam. They have created their own memorandum, madam. And next, madam, if I say, madam, at page 75, but there is a rule, madam, general financial rule.
Hmm.
At 175 rule, madam, there is a code of
Page 70.
5, madam. And it's at 8.
Hmm.
But rule 175, madam, code of integrity.
Just a minute. Rule 170.
5, madam.
Page?
Down below.
Page,
75.
page 75.
No.
Okay, what is this rule?
And this says that code of indicative. No
What
official
is this rule?
regarding particular tender. What are the norms to be followed?
No, this rule belongs to whom? Who issued this rule? What is the name of this rule?
General Financial Rule 2007.
General Financial Rule 2007. Okay. Okay, then
And next paragraph, your lottery people, lottery the next page paragraph, page 76.
what is this?
This is Assam Public Procurement Act 2007.
But it is applicable.
Yes, applicable, madam. As per this act, madam.
Hi, this is a entity belonging to the Union of India.
In India, madam, as per this act, madam, the act says that the Private Security Agencies Regulation Act 2005, madam. As per this act, section 3, madam, appointment of controlling authority. The state government shall not, by notification, designate an officer not below to the rank of the joint secretary in the home department of the state. Will be the controlling authority
Control authority of what?
of this act. Private Security Agency Regulation Act.
Okay. Now, how it is related to the tender?
But they have, since this tender is regarding.
Private security of yes.
So there is an act.
Yes. Anything relating to the the tender in that act.
But they are the controlling authority within the state, madam. They have been appointed by the central government, madam.
No, this act is for the purpose of regulation, control of a security agency. How it is related to a tender?
But they have said so, madam.
Who said so?
They have said
They will say that is to be as per in terms of that regulation, because they want that these security agencies.
Even if we approve this provision last Senate, madam, then also, madam, this general.
Now, what is the
rule
value of this contract? Let us see.
1.5 crore, madam. That is that, madam, page 60, madam. Sorry, madam, page 51. 51.
Page 51.
Madam. Bill number 3, last paragraph, madam, estimate cost 1.50, 34,198.
Estimated cost
1,50, 34,198. Around 1.5 crore, madam.
Yes, Gupta.
Lord, the outset, my lord, I would like to challenge the maintainability because the petitioners, they have no locus. The petitioner is an association, my lord, and the tender which has been issued, here the bidders would be the respective security agencies, my lord. They would be the prospective bidders. But in the instance case, my lord, the
Okay, we'll consider that. Come to the merit. Or you are only the technical?
My lord, on the before answering on the merit, my lord, because I have to take instruction on that. Because they have not.
Okay, you argue. Argue.
On the merit.
You argue on technicality. Yes, argue.
My lord, regarding the maintainability, my lord, my objection is, my lord, that since it's a commercial contract and the prospective bidder is not before this honorable court, and therefore, my lord, there is no violation of their fundamental rights. My lord. Even the representations which were given to the authorities were not by any of the prospective bidders that stated
By
that
association.
not by association, not
By the process.
this association is consisting of various security agencies. Those security agencies are the prospective bidders, my lord. They have never represented before the authorities stating that, my lord, they are facing difficulty with the tender.
Okay, we are giving them, see, if that is your ground, we are giving them liberty to approach the association. Until then, you will not proceed with the tender. This is your ground. Fine, we'll address that.
My lord, merit, my lord, and I will have to take inspection, my lord, whatever they have, that I will have to take an inspection, my lord, if it's on Monday, I will take inspection.
So till then, they will participate and don't open the tenders.
They have not participated.
Their members will be allowed to participate. subject to outcome of this writ petition. You need to appoint security agencies. We know our limitation. You need to appoint security agencies for a year. For how many years? For a,
I did not mention clearly, my lord.
for what period? Now I'll answer to your maintainability. The grievance is, Mr. Gupta,
My lord.
grievance is not as regards any individual right. Grievance is as regards deprivation of a class of tenderer by an tender condition which is under sellers and by the representative of those persons. So they say we don't have any individual because by virtue of that clause, you have excluded all our members. So they have come to challenge the clause, not any individual action.
That may be incorrect also because there may be some associations, my lord, who may be fulfilling that.
So they are saying we are the members, the
Because there
association.
is no resolution also, my lord. If there would have been a resolution of
That will examine.
Then in
So
that case also, my lord,
your
it
maintainability
is only
question,
filed
we
by
are
the
just.
president of an association, my lord, which is a registered society. They will not
Okay,
participate. in
fine.
that.
You file an affidavit on that. We are staying
And so
this.
far as
We are
the
staying this.
Tender
Including maintainability shall be remain open, but we are prima facie satisfied that 1
My lord,
crore tender,
My lord.
you are insisting upon hundreds of crores of turnover. So that will amount to exclusion of a class of person and
My
which
lord.
has been taken note of by the Vigilance Commission and which has therefore prescribed a rule. Prima facie, we are satisfied that that rule is, that prescription is being violated. We'll examine till then no security. Do you want that?
My lord, regarding the condition, my lord, I would rely on one of the judgment.
See, you have come to
My lord.
straight away the judgments. Okay.
My lord, on the
Okay, let us see the
My lord.
judgment.
because the imposition of conditions, my lord,
Mm.
that is discretion of the tendering authority, my
Mm.
lord.
We'll examine all this. We'll examine.
My
That we'll admit this issue rule and we'll examine all this. All these judgments.
My lord.
I was
Isn't
not,
it?
good note, sorted, madam. But
Yes.
not a-
So we'll
yes,
examine.
madam. It's a notice to madam. Till the till then, madam, please payment.
What you
Yeah,
propose?
none
You
of-
want that?
None of the, my lord.
You want that?
My lord, Monday, my lord, will fix it, my lord. I will come with inspection, my lord.
You come with instruction on Monday and
No.
but for Monday is the 27th.
Madam, my lord, 26.
Allow them to participate, subject to outcome, and we'll see on Monday. The members of the association.
My lord, will fix it on Monday, my lord. I will come with full inspection, my lord. Will hear on that date. Because
Ah.
27, my lord, is the next date.
Hmm.
So we will not.
Heard. Mr. S.P. Das, learned counsel for the petitioner. Also heard Mr. Gupta, learned CGSC representing the respondents. The petitioner is the petitioner is an association of the registered association of the consisting of the different private security agencies. Full stop. By way of the present writ petition, the petitioner has raised a grievance that for the purpose of which is the period, Mr.
Not from 1 year, my lord.
Where do you get that?
I've been informed, my lord.
Huh?
I've been informed, but it is not here, madam.
Yes, Mr. Gupta,
My lord,
is it your tender notice?
page 50 is the tender notice, my lord.
Huh? For which period?
Right.
No. No, 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 go, no, Taragodu. The respondent dispute university has floated a tender to hire security services from reputed and experienced security service provider for providing male and female security guards at Tezpur University. Full stop. The learned counsel for both the parties could not bring to the notice of this court the period of such contract. However, the tender notice reflects that the estimated cost of the tender is 1,50,34,198. Full stop. The tender document further prescribes under Section D for evaluation of technical bid. In the technical bid, for evaluation of such technical bid, certain marks are given, which includes execution of single contract value up to rupees 10 crores and up to rupees 20 crores. Full stop. Marks are also allotted against turnover, that is up to 100 crores, and between 100 and 200 crores. Even special marks are allotted against manpower on payroll, that is up to 5,000 and above 5,000.
1 year.
Full stop. The petitioner, case of the petitioner is that there are another prescription that minimal technical score should be 70 to be eligible in the technical bid. Full stop. The petitioners are aggrieved by such tender condition, inasmuch as it is the case of the petitioner that such conditions has been imposed only to exclude the certain class of contractors, inasmuch as such conditions are in violation of the notification issued by Central Vigilance Commission, which prescribes that for a work estimated for the cost of rupees 15 crores, the average turnover in the last 5 years where is that annual financial turnover against last 3 years should be 30% of the estimated cost, and in case of works which are to be completed during last 7 years should be not less than 40% of the estimated work. Full stop. Be that as it may, it is the further case that the petitioners associations has already represented. However, their cases are not being considered. Full stop. Mr. Gupta, learned counsel appearing for the respondent, submits that he may be allowed time till Monday to obtain instruction and to produce the record to show under what circumstances the aforesaid tender conditions were incorporated. Full stop. And the period of the contract.
The period is 1 year.
3 years.
3 years is 3 years. 3 years, 1 crore.
It's 63, Malad. The contract period is 1
Huh?
1 year, my lord. The contract period is for 1 year, subject to renewal up to 3 years.
Then what is the value for 1 year, 1 crore 50? Huh?
Only to favor a particular part.
So that will be renewed up to for 3 years, my lord.
3 years. 3 years subject to satisfaction.
Yeah.
Subject to a satisfaction, but ultimately 1 crore 50 lakhs for 1 year. Isn't that it?
It will be for 3 years because, my lord, it can be extended up to 3 years.
So whole 3 years is 1 crore 50.
Renewed.
Huh?
It will be renewed.
No.
The whole 3 years, my lord, because tender.
Okay, upor দিব দে,
Whole 3 years.
Mr. Gupta submits that the tender value is of rupees 1 crore 50 lakhs for 3 years.
3 years.
Then per year is there, that is rupees divided by 3, divided by 3, Huh?
Divided by 3. Yeah.
divided by 3 means
50 lakhs.
50 lakhs per annum. In view of the aforesaid, Mr. Police Jekyll shall obtain instruction and produce the record necessitating prescribing marks for execution of work up to 100 crores, whereas the contract value is 50 lakhs per annum. Full stop, considering the matter in entirety, it is provided that the member of the petitioner association individually may be allowed to participate in the tender process subject to outcome of the writ petition or the further order that may be passed on 27th.
But till then, they will not finalize anything, madam.
Huh?
Till then, they will not finalize anything. They will not open the tender.
So therefore, if you upload, let them, suppose we decide that proceed on Monday,
Yes, madam.
then you will be, and suppose Monday we dismiss your writ petition, then it's gone.
Yes, madam.
So you have 2 days time. So you either you can get ready for uploading. 26th is Monday.
Monday.
So till then you are at liberty to upload, submit individual.
But they will produce the original record, madam, of the tender.
That's why we have asked.
Original done. Original work.
Full stop. Further orders shall be considered on the production of such record.
Public.
And you have those judgments when can
I am, madam.
when can we interfere? We know our limitation in writ petition not interfering with tender.
No.
But if you say
Yes, madam.
the sun to be moon,
No.
huh? Then we are not powerless, Mr. Gupta. Forget about all these technicalities.
But EPC says so, madam, their own rule, madam.
No, CBC may not be in all cases be binding, but we have our own power. Therefore, what happened is, Mr. Gupta, when the moment the matter is started, you start a maintainability
No.
so seriously. That shows many things. That should be kept a little bit
Yeah.
for little back step. And more particularly in a writ court. That shows many things. Let this court not go to the merit. Let us kill it at the stage, because the moment door is open, we may be in trouble. Let us open this door.
Thank you.
Yes. And writ court is not powerless.
No.
There may be hundreds of judgments, but Article 14 is the touchstone of 226 courts. Always remember. Yes, next.
Public.
Thanks, the Lordship.
Yes, Mr.
My lord, this matter pertains to me, lord,
Hmm.
for non-releasing of a part.
This is item number?
18, my lord. Non-releasing of performance security deposit, 8,81,000, as well as, my lord, the deducted amount of 5% at 2.5 from, it is 21 lakh 27. In the meantime,
Contract is terminated.
my lord, does it certain development in the second phase? Lordship, by termination order, lordship will find at page 52 annexure 16, my lord. That is on 29/7/2023, my lord. My lord, the bottom 3 lines, my lord. Upon termination.
We'll issue a notice.
My lord, in this case, I am praying for some interim period, my lord.
What interim order?
Lord.
Is it not a section 9 proceeding.
Lordship, kindly give me some time so that I could satisfy lordship, that I'm entitled
But
to
will
inspection of the-
satisfy, admittedly, your contract is terminated.
But thereafter certain development, like,
No, let us understand, the contract is terminated.
absolutely.
There is a right, they are having a right to forfeit your security deposit under the contract. Whether they have their right in executing that power or exercising that power or not can be a subject matter
Absolutely.
under section 9 of the Arbitration and Conciliation Act.
Absolutely right.
If absolutely, what will you examine?
Lordship, only one point, my lord. They have said that, my lord, in the termination order, my lord,
Mm.
if I am failed to attend at the time of final measurement, my lord, they will issue the order, my lord, final order.
Huh.
And, my lord, then page 53 and Annexure 70, shall we have a look, my lord?
Mm.
This
Page
is
53,
Annexure 70. After termination, my lord. This is the issue to by the executive engineer, my lord.
Mm.
They have fixed on 7/23 for requesting me to attend that or for final measurement.
Mm.
I received on 10/73. They fixed issue on 3/8, fixed on 7/8. I received on 10/8/23. Without in my absence, my lord, they have taken my final measurement. Then, my lord, immediately, my lord, I made a review application before the authority, page 54, Annexure 18, my lord. Then, my lord, my review petition yet to be disposed of, my lord. That's, my lord, on 56 Annexure 90, my latest representation, that is on 12/2/2024, my lord. But kindly have a look, my lord, at page 68, my page 16, my final prayer before the authority.
Mm.
That it is most humbly prayed to your honor, may be pleased to release the remaining 4% work and also refund the initial performance to allow with the amount deducted amount to very next page, my lord, 2.5. Last prayer, my lord. It is further prayed that your honor may not take any adverse action until considering my above mentioned prayer. It is on 12 to May, but, my lord, very next day, my lord, they forfeited my performance security deposit amount, which we came to know only on yesterday, my lord.
already forfeited.
My lord, 8 lakhs.
Now, what is the interim order?
My lord, 21 lakhs is this remain in the
20 lakhs against what?
my lord, they have deducted as a exchange of bill, my lord, that is on 5% as well as 2.5%. My lord, that is still there, my lord. Same, my lord, is for the till disposal, my lord, the matter, my lord. Other some protection, my lord. Then my prayer, my lord, my representation pending. Let them on merit, ma'am, representation heart, my lord, and pass a speaking order, whether I'm entitled or not, instead of keeping pending in this matter.
That also cannot be.
Yeah.
Can we suppose there can be a claim petition under the contract, arbitration clause is there.
My lord.
You can make a claim, this you have committed mistake, this, that. File a claim petition. If they do not appoint you, go to an arbitrator, you will get everything.
Well, admittedly, by review as well as by representation, without.
These are not the way to raise dispute. When it's a contract of execution of work, can we pass an order empowering to do something which is beyond the scope of the contract? Heir and to lay. Those who are, he is not having jurisdiction to consider your review.
My lord,
You make a claim. If he says, okay, this is your claim, we are paying or not
my
paying.
lord, admittedly,
If they do not pay, then you will have to file an application under section 11 invoking
Hello.
condition clause. In the meantime, you will have to, if you are aggrieved that they are doing something, you will have to file an application under section 9.
it is often asked for, my lord. And one thing, my lord,
Then why read
my
court?
lord, the final measurement they have taken, but it's also violation of the tender agreement, my lord. And they
That-
expect,
Moment you say it's a violation of tender condition, it's a question of dispute under the arbitration clause. Can we decide?
my lord, come with observation so that this
No,
report can be lost.
We will not complicate things. That will complicate your case. File a proper application under section 9, get a stay, then a claim, file a claim. We should we now advise as a lawyer what to do? Dismiss this petition.
No, my lord. Lord, they issue notice in the I will think about it, my lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after week.
In this case, my lord, the petitioners are 9 members, lordship.
My lord, I am raising a question of maintainability in the petition.
This is item 19.
I am appearing for the capital.
Who are you?
For capital lordship,
Who are you? Tell us first.
the society has been entrusted with me lordship. attacked with me. And
Who are you? Tell us first. How a society can be tagged? A shop can be tagged? Huh?
my lord, the PDS,
There is a public distribution system.
my lord,
It is being done under the cooperative societies.
my lord,
Is that it?
Well.
The fair price shop owners are the shareholders and members of a cooperative society.
absolutely,
Okay?
Well.
Now, whatever right is there is of the cooperative society.
my lord,
Is that it? You were the secretary or president.
president.
You were the president of the secretary. You have been removed.
No,
The earlier secretary.
lordship, the PDS article lordship, they were directed to be lifted by my society, lord. And they are suspended, the license has been suspended.
Where is that?
Yes, lordship, page 47.
You are the members of this.
We are the members, 9 members, Lordship.
Against that,
My lord,
lordship, appeal
the
is there.
rational number 6 is.
Where is the impugn order?
Page
Page
40
44,
47.
47, Lord. My lord, kindly see, Lordship. Whereas may I read, Lordship, this part. please? Whereas the complaint was received against some executive members of Doloiga DPSS regarding illegal diversion of MDM rights from DPSS. Whereas the matter was duly inquired into by C. Rupam Huya, Inspector Food Public and Distribution and Consumer Affairs, and submitted his inquiry report, which reveals that the executive members, in connivance with others, have diverted and misappropriated 27 quintals midday meal rice, depriving the primary students, manipulating the stock register of midday meal rice, and thereby the executive members, in connivance with others, have contravened terms and condition number 3A81 of the CPS license issued to MS.
Where is the standing council? Who will represent this department, this district commissioner Murigaon?
Otherwise also lordship the order, the order was issued lordship on 21, 2024 lordship.
That's correct. But Mr. Gogoi, look into this.
Lordship.
Who is this Doloigao GPS has got? What is their antecedents? When your society is established, how you were related to the earlier society? Tell us that. You file on affidavit on note.
Nothing is there.
Huh?
I'll file lordship, affidavit, lordship. In fact, lordship,
When your society was established, tell us. You are on caveat, at least tell us that.
that society established long back, lordship.
Hmm. When you become president of the society?
That information not.
Now, suppose this is by district commissioner, this is suspension of license, isn't it? No, cancellation.
Suspension.
Any show cause notice issued to you?
Nothing, Lordship. No.
Huh?
No.
In 90 days, we have to issue it. Last it was issued on lordship 21, 54. Just is the otherwise.
Because they will have to issue a notice so that they can respond.
Respond. The team issue matter. Today
That also thing.
Today it's the team issue.
That about lordship, there is a.
What is-
provision-
My lord, respondent number 6, Lordship. Respondent number 6, that my lord, son of the president, Lordship. Hacked his Lordship.
No, that we know.
Yes, Lordship.
Just tell us in a legal position. You may have a very good case on merit,
Lordship.
isn't it?
Yes.
What the procedure of cancellation of license? Is it a suspension or cancellation?
Procedure,
It
my
is a
lord,
suspension or
in
cancellation?
the PTS, my lord.
No, no,
order,
is it this order is suspension or cancellation?
This is suspension.
It's a suspension, temporary suspension. Now, what is the procedure for suspension?
Procedure, my lord, it is not prescribed in this, my lord, order, my lord, clause 15, kindly see, Lordship.
What it
Clause
says?
15 says, if any, sub clause 1, if any license or his behalf contravenes any of the terms and conditions of the license, then without prejudice to any other action that may be taken under the Essential Commodities Act.
Hmm.
So and so, his license may be cancelled or suspended by any order in writing of the licensing authority, and entry will be made in his license relating to such suspension or cancellation.
Hmm.
Now, my lord, cancellation, my lord, that is okay, lordship. Now, next, my lord, close to,
Hmm.
close to.
Hmm.
No order of cancellation shall be made under this clause unless the license has been given reasonable opportunity of stating his case against the proposed cancellation, but during the pendency or in the contemplation of the proceedings or cancellation of the license can be suspended for a period not exceeding 90 days without giving any opportunity to the license of stating his case. Now, till now, my lord, we have no notice has not been issued.
So what is the
Now-
period? What is the, no, let us
Yes.
understand. Don't jump.
Lordship.
We can exercise and protect your right.
Yes.
What is being given.
Yes.
Now tell us. They say that they can suspend, but it cannot be cancelled within 90 days.
Yes.
And you will have to give a notice,
Lord.
a reasonable opportunity of hearing.
Yes.
So if we read both these clauses, so they can keep a license under suspension till 90 days, not beyond that.
Not allowed.
And for cancellation, they will have to issue a notice. Now,
Right.
admittedly, this order dated 21/20/24 is a order of suspension.
Suspend.
Now, that is not yet been cancelled. And they have a time to give you notice till March 28.
Lord. Now, we have submitted representation before my lord issuing show cause notice. But that is not yet been, my lord, has not yet been disposed of, lord. We have not, my lord, a call for hearing, lord, nothing is here, lord. That may be directed to be, my lord, disposed of, lord. On the other hand, lord. Next, my lord, clause 16 kindly see.
Yes, what is
When the, my lord, it can be entrusted, lord. For clause 60, when a license issued under this order is cancelled or suspended, the stock of notified articles shall be disposed of in such a manner as may be considered appropriate by the licensing authority. Stock, lordship. Stock means in my humble submission, my lord, which is this under in the stock of the, my lord, licensee, lordship. This can be, my
they
lord,
do not
disposed
want
of.
to, they want to continue because suppose your stock is sold, then
Yes.
how distribution will not be effective.
Any other authorities there, my lord, the secretary is there, the secretary is there, there is no secretary. Fact is, lordship, that is why, my lord, Malafide, what is the Malafide, lordship? The, my lord, secretary is responsible, lordship.
Okay, now
My lord,
we
why
will
I'm-
we'll play our
otherwise members,
we will play our role as a licensing authority.
My
That
lord,
is the
not-
proposition.
Not that, lord, not that, I am submitting.
Because you are coming, that
I may be allowed
facts,
to-
facts.
I may
So
be allowed-
facts determination is done by the deputy
My
commissioner.
lord, one thing I may be allowed to say. The retired secretary, lordship. Secretary, my lord, was given retirement by the members.
Hmm.
My lord, on that grounds, lordship. My lord, secretary clapped hand with the president.
Hmm.
My lord, get the license suspended and the get your son benefited, lordship.
Hmm.
My lord, accordingly, my lord, the president and secretary, my lord, informed the DC.
Hmm.
The shortfall is there.
Hmm.
So I am going to retire.
Okay.
My lord, deputy commissioner, my lord, atmosphere was created, lord. And the license was cancelled, my lord. The benefit goes to the, my lord, president and, my
What is
lord,
the cancellation of license?
sorry,
Oh.
suspended, my lord.
Okay. Hmm.
Now benefit go to the, my lord, directly go to the, my lord, son and the president, lordship.
Now,
My
what
lord,
kind of
second-
order do you want?
My lord, now, what is the, my lord? It may be distributed with some other authority. It is, my lord, the respondent number 6. My lord has given, my lord, filed, my lord,
What is your
KVS. What
happiness?
interest he has?
What is your happiness, whether it's distributed by him or somebody else?
Not distributing it properly, lordship. My lord, we are the members. We are my lord, on, my lord, for the benefit of the, my lord, society, lordship. The business of the society is, my lord, is
Who are you?
members, my lord. Out of 13 members, lordship, we are 9. One expert, 10.
How many members are there?
My lord, 13 members, lordship. One expert, my lord, president is the.
What is your prayer?
Prayer is, my lord, it may be, my lord, interfered with lordship and the, it may be state, my lord, the respondent number 6 is a non-existing entity, lordship. Good,
So
nothing,
what
no-
is your
no
grievance?
restrictions there.
Not getting materials? Or that who is your who runs the society?
My lord, society is running by the, my lord, members, lordship, the board of directors.
Super.
Now after retirement of the, my lord, secretary, it is under the
Okay.
government.
Okay, you want to add
Yes.
something more? Any point you want to add?
My lord, one thing, my lord, I want to, my lord, communicate.
Well,
with
not
the-
one thing. You can argue
The
two, three
respondent
things.
number 5, my lord, is still, my lord, transferring the fund to other non-existing persons lot. I have, my lord, annexed the, my lord, bank account. But this is going on, my lord, because of, my lord, president and secretary. My lord, members are the, my lord, these elected persons.
The society which was, societies whose license is suspended is not before us.
My lord, cancellation, my lord,
Sus-
wholesale
The
license.
society which,
Wholesale license.
huh?
Wholesale license is suspended, Lord.
So
That is the
wholesale
business of the
license,
society.
wholesale license belongs to the society.
My lord, that is business of the society. Lord, society is loss,
Huh?
suffering loss.
Who is
Society-
before us?
We are member on behalf of the society, Lordship. President is not having, he's the, my lord, respondent, Lordship. Because the president is benefited, but his son is, my lord, distributing, Lordship. That is the malafide. The problem is there, Lordship. President, secretary, and his son, we are the members, we are helpless, Lordship. Blame is given to the members. Secretary, my lord, retired. Till now, he is, my lord, transferring.
Secretary also retires.
Yes, Lordship.
Okay.
Because of
He
that,
is son of secretary.
president, Lordship.
President, son of the president was the secretary.
My lord, he's saying that he is the, my lord, now I don't know what is he, my lord.
You will have to know.
Agent good, Lordship.
Uh-huh.
Agent good, Lordship. Agent good. My lord, no registration is there, nothing is there. My lord. in the
Yes,
name of- this is
show your
non-existing,
license.
my lord, entity, Lordship.
Show your registration and license.
Lord, that the document, Lordship.
You are on caveat, mister.
Not only this document, Lordship. My lord, so far.
Your
this-
activity shows because it's a specific stand.
My lord.
Now that's why I asked at the initiation, this may not be a case for interference so far relating to the suspension.
My lord.
But what is your right? If there is a absolute malafide apparent on the face of the record, then we will not. Yes, Mr. Gogoi. Who is he? At 2. Mr. Gogoi, at 2, who is he? What is his nexus? And what is this cooperative society and where is their license? Have it by WhatsApp. And if not there, we will say that any registered cooperative society is not him. At 2. Yes.
So we are a registered pharmacist, our license has been cancelled.
Mm.
Of course, there is a alternative remedy is available under 36(4) of the Pharmacist Act. Once my,
Not only remedy,
madam,
but also determination made. Nothing survives in this petition. In view of the writ appeal.
my lord. So, in view of that, my lord, I may be allowed to get that, protection and we will move, let them produce.
But we do not know whether that protection is period is what.
They have been terminated in cancelled in June.
Okay.
After 8 months now they have approached. They won.
What is the
everything today.
period for appeal?
My
1
lord,
month.
1 month, because they have to, process time, I just.
See, whatever, who preferred this writ appeal?
Some of the.
Some of the members. So, writ appellate court in fact closed all the issues,
My
though
lord.
it was against an interim order,
My lord,
not granting an interim. Notice was issued.
my lord,
You went to the division bench.
my lord.
The honorable division bench says, forget about everything.
Right.
You are given a liberty to approach the appellate forum. Now,
Right.
when it was given
Right.
in the month of November 2023,
Right.
these petitioners might have an existing right as on date.
Right.
But can we give the same relief in a sitting singly when the law does not permit?
No,
Where is the period? What is the period?
I'll just, Lordship, kindly take up the, just look into the impugn order that will clear, Lordship. Page 318. 318.
Yes. Yes.
My lord, after cancelling, plus next paragraph, my lord. This has a reference of Executive Committee resolution dated 17/8/2022 and confirmation by State Council under Section 36(3) of the Pharmacies Act on 20th January 2023. Now, these two executive committee resolution as well as confirmation made by the State Council has to be given to us. Then we can move to the appellate forum under 36(4).
Okay, give us the provision.
My lord, this is.
So your case is that until we have a period of limitation of 3 days, 3 months from the date of confirmation, and there is no order of confirmation.
Because, my lord, under 36(1), the
Executive.
committee has, my lord, passed the order. That resolution has not been provided.
Now, where is a statement that you have not been given copy of the executive confirmation by the State Council
Because,
and the resolution of the executive committee?
because the, my lord, in fact, in the.
Where is a statement?
Really, my lord, they must challenge this particular order. That is a resolution is always there in the minutes, my lord, in the pharmacy council executive body. That need not be furnished to everyone, my lord, otherwise.
No, but suppose question is that this is only intimation of the decision.
Yes,
This
yes.
is not an appealable order.
Lord.
This order communication of register is not an appealable order. What is appealable is that executive order confirmed by the State Council.
Finally
And
confirmed.
yes, until and unless State Committee confirms or 3 months.
My lord.
So appeal is period of limitation is confirmation of the decision of the executive committee by the appellate State Council. So
My lord.
appeals period will depend upon the receipt of the
Yes, that and all.
That-
Yes. Moment they receive it.
that from that it is appeal will be counted. So if that is there, if there is any statement that this has not been served, and if you give that that we are giving the handing over the copy, then we'll give that and say that that appeal will be period will be counted in terms of so and so from the date of receipt, and they'll prepare an appeal.
Lord.
That's all. Where is your statement?
My lord,
Go through it. We are coming
My lord.
that this was not served. Any statement?
Yes, my lord, page 54.
Page 54.
Clause number 8. Paragraph starts from 27.
Page 54.
My lord, clause C. Decision or order of the executive committee never been communicated to the present petitioner as per clause 9 of paragraph 6 of the judgment dated section 5. Earlier there is a litigation.
No, we know that.
Yes.
There was a specific direction.
My lord,
A period was given
My
in
lord.
terms of that you approach.
my lord,
Then according to them, they have decided. Thereafter, 2-3 repetitions were filed.
absolutely.
In some cases, there was stay, and
lord.
in some cases, there is no stay.
My
When there was no stay, you went to division bench. Division bench says, okay, you prefer an appeal. Ultimately, all these repetitions will be, fate will be the division bench
My lord.
order. So instead of keeping it pending, you can prefer an appeal.
Yes.
And now only thing that will depend upon is whether this order has been furnished to you or not.
Right.
Gogoi, They have taken a specific stand at
Not-
54,
Not been funded.
not been furnished.
In that line, Lordship,
Okay, hard.
taking a cue to the, my lord,
Okay,
division bench order.
okay, that is hard. You are Mr. Sharma?
My lord.
Sharma, learned, S. Sharma, learned counsel for the petitioner. Also heard Mr. Gogoi, B. Gogoi, learned case counsel appearing for all the respondents.
All the respondents.
All the respondents. Full stop. The petitioner this court under its order dated. Where is the earlier judgment? Where your petitioners?
My lord, page to
215?
215, cooperating lordship will find 2 to 4.
2 to 4.
Right.
Equal. This courts under its order dated
31/5/2018.
31/5/2018 passed in WPC 3822 and other connected cases.
Fine.
Directed the respondent number. The executive committee is the respondent number.
Executive committee respondent 2.
Directed the respondent number 2. Who is Assam Pharmacy Council respondent number 1?
Yes.
Directed the respondent number 1 to consider the case of the petitioner so far relating to consider the case of the petitioner as regards validity of their licenses in terms of the section 36 of the Pharmacies Act.
My lord.
1948. 48. With an observation that the decision of the executive committee under section 36 of the Act, while taking a decision, it was also observed that while taking decision, the executive taking decision in exercise of power under section 36 of the Act, the executive committee was to have strict regard to the findings, certain findings in the aforesaid judgment. Full stop. Subsequently, the pharmacy subsequently the exercise was carried out and the licenses of the petitioners were cancelled and name of the petitioners were deleted from the roll of Pharmacy Council by the impugned order dated
Until various dates.
by the impugned orders which are under challenge in this writ proceeding. Full stop. Some similarly situated persons also approached this court by filing WPC
3340, my lord.
WPC 5335 of 2023. Isn't it?
My lord.
5335 of 2023. However, the coordinate bench did not pass any interim order staying such orders. Full stop. Staying such orders passed under section 36 of the Act by the executive committee of the Pharmacy Council. Being aggrieved, those petitioners approached the Honorable Division Bench by filing writ appeal number
431.
431/20.
Oblique 20.
2023. Full stop. The Honorable Division Bench, under its order dated 24/11/2023, dispose of the appeal, directing the appellants to approach the office of the Assam Pharmacy Council within a period of 2 weeks from passing of said order. Order in terms of section 36 within bracket 3 of the act, isn't it?
My lord.
36 3 of the act, that is to prefer an appeal. Full stop. In this case, a specific statement has been made that statement has been made that the petitioner has not been provided the copy of the order passed by the executive committee of the council in exercise of its power under section 36, nor any confirmation has been made in exercise of power under not any confirmation has been made by the state council in exercise of no copy of the confirmation made by the state council in exercise of power under section 36 within bracket 3 of the act has also been served upon the petitioner, and therefore in terms of section in terms of section 4 subsection 36 of the act, the petitioners are not in a position to prefer an appeal also. Full stop. Mr. Gogoi, on instruction has submitted.
No, I'm not.
Comma. Then what is your stand that a copy has not been granted? That will have to record.
No, here, my lord, so far as this impugn order is concerned, my lord.
That is
There
appellable order.
Nothing, no, it has been mentioned that, my lord, this particular confirmation is enclosed or.
No, not given. So the order impugn in the the impugn order herein reflects that the aforesaid is a communication of the register of the state committee,
The Assam Pharmacy.
a register of the Assam Pharmacy Council, and the same is a communication of the decision to remove the name of the petitioner from the register of the council, and there is nothing material to show that the copy of the decision of the executive council or any confirmation made by the state council is provided to the petitioners. Full stop. That being the position, it is that being the position, learned counsel for the petitioner submits that they are still willing to prefer an appeal subject to furnishing them a copy of the decision of the executive committee and the order of confirmation by the state council. Full stop. As there is already an alternative remedy of appeal under section 36 within bracket 4 of the act, and in the meantime, the Honorable Division Bench in a similar circumstances has relegated the similarly situated petitioners to approach the appellate authority, this writ petition also stands disposed of, directing the respondent number. Who will give the copy?
Well, it will be the Assam Pharmacy Council.
Okay. By the respondent number?
1.
Respondent number 1 to give to hand over and serve a copy of the executive committee decision, whereby a decision to remove the name of the petitioner from the council was taken, and a copy of the confirmation of such decision of the execution arrived that made by the state council be furnished to the petitioner within a period of, Mr. Gogol,
2 weeks.
within a period of 2 weeks from today. The learned counsel for the petitioner shall furnish a copy of this order
Before the Assam Province,
before the Assam Pharmacy Council.
along with a copy of the petition.
Al-
Since it is disposed of the commercial sales. At
Okay.
least the impugn orders will be annexed.
Okay, along with a copy of the writ petition on the receipt of such within a period of a week from today. Okay, from a week from today. Full stop. Thereafter, on receipt of such determination made by the executive committee and the confirmation arrived at by the state council, comma, the petitioner shall be at liberty to approach the appellate authority under section 36 within bracket 4 of the Assam Pharmacy Act 1940
Within a period of 30 days. It has been
49 with the 49 within the prescribed period period.
30 days.
That is whatever within a prescribed within a period prescribed under section 30 within bracket 4 of the Act 1947. Okay. Full stop. Accordingly, this represents and disposed of. While parting with the records, it is submitted that this court has not entered into any merit of the decision taken by the executive committee or the state council, and therefore the appellate authority shall be at liberty to consider all the grievances of the petitioner in terms of the pharmacy in terms of the Assam Pharmacy Act 1948.
So till then, my lord, the impugn order may be taken till the appeal is
After
completed.
8-9 months. they
Because
have-
This is 2006.
They have not.
No, no, see, no interim order was passed in the earlier proceeding.
Earlier,
No, there were passed, but division bench has not even said while relegating
My lord,
that,
kindly see that, my lord,
No,
the
some
order,
of
the division bench has.
where is that any division bench order?
404, my lord.
Huh?
Last page,
Last
404.
paragraph, otherwise, yeah. Till those
404,
documents
my
are
lord,
furnished.
till the copies of resolution of executive committee and the confirmation by the state council is furnished to the applicant, the impugn orders of council shall remain.
Where?
My lord, 404, last page, my lord.
Till the, okay, Mr.
Sir,
Gogoi.
here, my lord, why I'm saying is, they approached in time.
No,
Here,
no,
after
but-
8 months.
No, that is understandable, but
Yeah.
they have not been able to obtain their right
My lord,
for non-furnishing of documents. This is, you have invited
Only
this.
these 2 years.
Okay.
not this,
For, okay. Till that last paragraph, till copies of the resolution of the committee and the confirmation by the state council is furnished to the appellants, the impugn orders of cancellation shall remain suspended. Okay,
my lord.
Well,
that I missed that line. আরে পিছত করে দিও ডিকটেশন আছে ঠিক আছে করে দিও। None appears for the petitioner on call. Yes, who is representing the respondents? Where is the order? No state, office note dated. The. Where is the office note? No steps has been taken. Office note dated. 11/1/2024 reflects that no fresh steps has been taken for service of notice upon respondent number 2 and 3. Accordingly, the respondent number 1 has also in the meantime transferred. Accordingly, the contempt petition. Yes. Yes, anything survives.
I'm intimated them, no communication.
Closed. Nothing survives. That might have this respondent number 7. There is a direction he might have returned 12 lakhs rupees. Will they not contact? We have closed it. If necessary, they will come. Huh? Good. What is this writ petition?
Contempt is connected with this petition.
Don't appear. None appears for the petitioner and call. Writ petition stands dismissed. Interim order if any stands vacated. Nothing that has become influx was on the day 1. And subsequently, Deputy Commissioner has taken a stand that though initially he was not aware of this order, but subsequently he is acted. That's why matter has become infraction after a week of passing of the interim, or even after filing of the contempt. Yes. Miss Kesar jodi ase silo, jodi basi ase close. In view of the order passing, represents stands close. Complied.
Complied.
Okay, Mr. Dutta, Learned Counsel for the respondents. Respondent number 1 submits that pursuant to this court's order dated 11/2/2021 passed in WPC 1794 of 2020 has already been complied with. An amount of rupees 2 lakhs as ex gratia grant was released to the next of the kin of the deceased person who died in a motor vehicular accident. Full stop. In view of this, in view of the aforesaid submission, the contempt petition stands closed. The communication, the fund release order dated 21/2024 is kept on record and marked as document X.
22.
22 is marked as document X. Give a copy to him.
Look.
May I please your lordship, in this matter, Dinath is appearing and he is on Lexington court number 1,
In-
your lordship.
Is it complied with or you need some time to file affidavit?
Your lordship, I think he is.
Okay,
Maybe fix it too, he has instructed me to fix it too, your
fix it too. Okay, he might have some instruction. Okay.
lordship,
Item 46 also?
yes,
Yes, 45 and 46 are two.
fix it. Your lordship, for item 53 and 26 also, he asked to fix it too,
53 and,
26.
okay,
Oblige, your lordship.
53 and 26.
26.
53, let 26 come, 53, okay? This next. Forty-seven. Okay, okay.
And as per direction of the honorable court, my lord, we
Hmm.
took step, my lord, registered post as well as Dusty, my lord.
Hmm.
Yesterday, I filed an affidavit to Dusty Service, my lord.
Good, Dusty upon whom?
Dusty upon the respondent number 7, my lord. I filed the affidavit. I think, my lord, it was not on record, my lord. Yesterday, I filed the affidavit.
Okay, it is submitted that pursuant to this court's order dated 24/1/2024.
Yes, my lord.
21 for the petitioner has taken steps for issuance of notice upon respondent numbers
7, my lord.
7 through Dusty. Are you appearing for 7?
My lord, I'm appearing for respondent number 6, my lord.
Okay, anybody appears for 7? No, an affidavit has also been filed in this regard. The affidavit is not on record. Registry to take the same and list this matter after a week.
My lord, lord, sir, can you may fix it date, my lord?
Yes, give a date.
My lord, on my lord, 12 March.
12th of March 2024. In the meantime, the respondent number 6 may file their,
Lordship,
in the meantime, the other respondents may file their pleadings.
there is an interim order, my lord.
Huh? Interim order pass earlier shall continue till then.
The name of missing autonomous council may be reflected.
Okay, registry to reflect the name of the standing council missing autonomous council.
Next same.
Next same,
Yes, my lord.
49,
Yes,
same.
yesterday also, my lord. That is-
Oblige, my lord.
May I please your lordship? Lordship, I am appearing for respondent number 4, lordship.
What about 4? What about 5 and 6?
Lordship, we have instructed to appear on 4, lordship.
Only on 4.
Yes, lordship.
Okay, okay, this court, this court's under its order dated this court's under its order dated 8/2/2024. Huh? 8/20/2024. Directed the, pursuant to this court's order dated 8/2/2024. The petitioner has taken steps for issuance of notice upon respondent number 4, 5, and 6 to Dusty and has also filed an affidavit. Stop. The respondent number 4 has entered appearance. However, respondent number 5 and 6, has not entered appearance. Peruse the statements made in the affidavit and service upon respondent number 5 and 6, 4, 5, and 6 are accepted. Full stop. Accordingly, this matter is ready as regards service. List this matter in the admission column. In the meantime, parties may exchange their.
Very urgent the matter, but because this is only 30 days work, my lord, it will be over any day. My lord, what has happened, my lord, they were supposed to produce they have to produce a record, my lord. Our basic case is, my lord, while opening the financial bid, my lord, technical bid, all of us qualified. While opening the financial bid, my lord, they did not inform us. Without informing, my lord, the financial bid was open, my lord, and the work has been given to the private respondent. That is our case, my lord. And my lord, the work is to be completed in 30 days.
How you are prejudiced?
My
If you are, do you dispute that my rate is not a, this is, there is a manipulation?
We have stated that. We have alleged that. And we have, in fact,
Okay.
sir, we have made the
Okay, when give a date, please this matter on.
the next Wednesday, my lord.
Lordship, we have not received any copy also.
Wednesday may be difficult. You make a mention.
Then let me Friday, my lord, because this Friday is the holiday. Man.
Okay.
That's some urgency, my lord, because that's the reason, my lord. Otherwise, my lord, the work will be completed and my lord, will be interest to us.
No, where is your statement that there is a manipulation in your price?
Exactly, my lord. My lord, para 7, there's no information, my lord.
Para 7?
Yes, my lord. Para 7, there is no information was given, my lord. And my lord, para 9, my lord.
Okay. Mr. Datta has expressed some urgency express urgency in this matter as the execution of the work might complete in the meantime by the respondent number respondent number 6. Respondent number 6. First up, as allegation has been made that the bid of the respondent number 6 was manipulated to bring him lower to the price offered by the petitioner, inasmuch as the petitioner was not informed regarding the date of opening of the bid. First up, Please this matter on
Witness. Friday is a holiday.
next Monday.
Next.
Next Monday.
Diplo.
Not this Monday,
My lord, thereafter.
thereafter. 4th of March, 4th of March 2024.
Can it be 5 or 6 for the PP doctor will be not here?
5th of March 2024. In the meantime, full stop.
My lord,
On
can I
the-
pray
on
for
the-
a status quo, my lord, then?
No. On the next date fix, the records pertaining to the award of the contract shall be kept ready.
Item number 51 is also similar, my lord, but the affidavit, the affidavit will be filed today morning. Same.
That matter also I'm
There
appealing
appears-
for.
Okay, but affidavit is not on record. Call the affidavit, we'll pass the order later. Huh? If
Affidavit.
you give a slip, then we'll pass this
My
order, but affidavit should be on
My
record.
lord,
Same order, give a slip and bring the
Yes,
affidavit in the
I'm
record.
giving.
We can pass the similar order, that's not an issue, but subject to coming of the affidavit.
Yes.
Number 1, and number 2, if it is not comes, we'll adjourn this meeting.
My lord.
Yes.
Yes.
Wait, these are not.
Yes.
Lordship, on the last occasion, madam.
Anything you want to add?
Yes, Lordship, one point, madam. Lordship, we had come to the point that it is not a case of fraud or misrepresentation, but the conduct of the petitioner is not acceptable, my lord.
Mm.
And my lord, being the principal, my lord. But my lord, if the conduct is not acceptable, my lord, it will be a misconduct, my lordship. And my lord,
We understand. You need not argue.
Lordship.
We will pass the order after the
Lordship,
matter.
one
Sir.
point, Lordship.
No 1 point. We are allowing your repetition.
Allow it.
What do you want to add? We are allowing your repetition.
Lordship.
We thought over. We cannot go to that extent.
Yes, Lordship.
That may be morally wrong, but that we cannot pass an order on morality. Morally, we are not convinced of your client's conduct.
Yes, Lordship.
That is for sure. And that observation will also be there. That is for sure. We'll pass this order after admission, Shobha Sarwal.
Yes.
You'll be here.
Yes,
If you want to add something.
Yes.
Okay, you can.
Lordship,
go. Yes. Morally,
Lord.
of course,
Lordship.
but we cannot run courts on morality.
Lord.
Constitutional morality, not this kind of.
Lord.
Yes.
Lordship.
Lordship.
Lordship, in this petition, the challenges to a notification by the Labor and Employment Department regarding minimum wage. Lordship, by this notification, the department has sought to bring within a category of semi-skilled labor, Lordship, certain activities like screening, pruning that takes place in Pigart. Lordship, if I may take your Lordship to the order dated 39/21
Where is that order? Yes.
of this honorable court, Lordship. Order dated 39/21. Lordship, rule has already been issued in this matter.
Huh.
Lordship may fix it for hearing.
We are hearing it right now.
Lordship may take it up for hearing on some other day.
No, sorry.
Lordship, my difficulties, Lordship, in this case, Lordship, initially we were being led by senior counsel.
That is not our concern. Senior council is not a concern. It should be clear. This is a matter of 2015. We are hearing it.
Lordship may give me a thought that next week.
No,
Lordship, any-
no, nothing. You proceed. Or we'll do on our own.
So Lordship, our main contention is Lordship, as per the minimum wages act, section 20.
What is the MP order?
Lordship, page 54 is the MP order.
Yes, 54. Yes. Who is representing the government? Yes.
Lordship, by this
Hmm.
notification, Lordship, may I read?
Hmm.
Where is the governor of Assam?
Minimum wages act, yes. And the rules, Assam rules, yes.
Where the governor of Assam is of the opinion that the employment in any plantation, that is to say, any estate which is maintained for the purpose of growing tea, rubber, coffee, and cinchona has already been scheduled in part 1 of the schedule under the Minimum Wages Act so and so. And whereas it is felt that some level of skill for execution of work like plucking, pruning, chill hoeing, spraying of insecticide, pesticide, etc., is required in respect of work relating to tea plantations of Assam. Now, therefore, in exercise of the powers conferred by Section 27 of the Minimum Wages Act, the governor of Assam hereby gives notice to its intentions to add the following occupations as semi-skilled work for the purpose of fixation of minimum rate of wages proportionate to the category in accordance with law. Any suggestion, objection which may be received from any person in respect of the said edition on or before the expiry of 3 months from the date of publication of the certification in the Assam Gazette will be considered by the state government. But the occupation is given below, work relating to plucking, pruning, so so Lordship, these works, they are already within the category of Lordship unskilled work, Lordship, as of now. So this notification,
They were brought upgraded to semi-skill.
Lordship, but as per our contention, Lordship, the Section 27 of the Minimum Wages Act only confers power to give wages, Lordship, cannot bring in a new category of work, Lordship. That is the main contention.
Let us see section 27.
Power of the state government to add to schedule. The appropriate government, after giving by notification in the official gazette, not less than 3 months notice of its intention so to do, may, by like notification, add to either part of the schedule any employment in respect of which it is of the opinion that minimum rates of wages should be fixed under this act, and therefore the schedule shall, in its application to the so be deemed to be amended or.
Okay.
Lordship, now, Lordship, it is not the case that this particular class of work was not there in the schedule. It was already there. Now, with this notification, the government is trying to create a new category of work.
So according to you, there is no scope of upgradation.
Lord.
Only they can exercise their power under section 27 only to add new. There is no scope for bringing unskilled to skill.
Lord.
This is your argument. Okay. Okay, so according to you, this is section 27. Is there any other provision which may, under which the government can change the category under the act?
Lordship, in the affidavit in opposition which the department is filed, Lordship, there is no mention of.
What is the affidavit? Let us see the scheme of the act. What is the object of the act? Yes, who is representing Mr. Gogoi, the state?
According to the file, we ask those.
Okay, you'll be here. Let us see. These matters are pending since 2015. There is a stay order. Let us understand what is what. We may continue if necessary, but let us start the hearing. Mr. Sahala, this your arbitration, there are many arbitration matters. I think you are waiting for that.
Yes.
Now, these are section 11 applications. It is to be done by the Chief Justice or his. So now, why these matters are listed, any notification delegating the power or?
My lord, these are listed, my lord, as per the justice, my lord, it's in all benches. They say, my lord,
Your
But
lordship,
if tomorrow there is a question that this judge is not having authority under law.
well, that is, justice has
Huh?
said, otherwise, my lord, they cannot list it. That's why allowed, my lord, to list it to sign it.
No, that's why I'm asking is we'll have to take this with the registry. I have also passed an order.
Yes.
But I've tried to look into this, all this matter,
Yes.
whether there is any specific delegation by the Honorable Chief Justice. Delegating his power and assigning a bench. That can be done. But it must be assigning a specific bench. Once it is coming to me, then it will go to some other. What is this? Any notification?
Roster, it's a roster.
No, there must be a notification. But
22 meters are court number 2. So like that, because 1 meter
so these matters, can this court take up?
that I, but they are saying that they are, because 1 meter.
No, there may be two things. One is that a specific individual judge is being delegated the power under section 11. That so and so judge will exercise in this case. Well and good. That delegation is there. Or there may be a general notification saying that all these matters, Chief Justice has hereby delegate in exercise of power under so and so to take up this section 11 petition to this bench. Or as maybe as per roster of bench 4. Where is that?
My lord, in fact, my lord, that is happening, my lord, bench 4, it is coming, my lord. And last week, my lord, it was before the.
I passed an order.
Yes.
I was taking some bench 3, then it is. So I was thinking whether it is without jurisdiction. That may question. Like
Your
air
lordship,
unto lay.
your lordship, I'm appearing in item 25. That is also an arbitration petition. I would just like to make a small point. Under the Arbitration Act, your lordships, the Chief Justice is not the only authority. The term used in the Arbitration Act, Section 11(5) is the High Court. So your lordships is very much competent to take up these petitions and appoint the arbitrators if your lordship
Is there any
desires so.
change? Because earlier it was Chief Justice.
Your lordships, the amendment after the amendment to 11(5)
Okay.
and 11(6),
Okay.
the phrases used are High Courts and Supreme Courts, your lordships.
Okay. Okay. Then there is no problem. Okay. We'll take up. You go through it. That was the question in my mind that I missed. Okay.
Oblige, your lordships.
Yes. So here what we need to interpret is minimum rates of wages should be fixed under this act. So whether this minimum rates of wages under this act will amount only to a fresh inclusion. This is the issue. According to you, this will amount to a fresh inclusion. Suppose an employment is already out of any of the schedule. Now, government wants that this should come into the schedule. Then only, not otherwise. Already existing schedule, there is no scope for the government to do so under this act. Therefore, this notification could not have been issued under section 27. Now, how schedule is defined?
People find scheduled
Hmm?
section 2G, scheduled employee.
Section 2G.
Carried.
Section 2G. Okay.
Scheduled employee.
2G, just a minute. 2G, schedule employment. Okay.
Scheduled employment is an employee specified in the schedule or any process of branch of work forming part of such.
Now, said where are the schedules?
But its schedule will lordship will find in the last part of the act. Scheduled part 1, 4.
There are 3 schedules. Okay.
Schedule 1, part 1. schedule
Under the after the act
Part.
or after the rules? After
the
the
act.
act. Okay, schedule.
I case lordship will call in item 4, employment in any plantation. That is to say, any estate which is maintained for the purpose of growing so and so or coffee.
So, the schedule, part 1. What is this part 1? So, which is the serial number?
4.
4 serial number, employment in any plantation. Okay, and then?
This is the only.
This is the only schedule.
As far as tea planting.
And what are the other schedules? What are the other schedules?
There are 2 parts. One schedule
Part 2.
Part 2 is lordship employment in agriculture. That is to say, in any form of farming, including the cultivation and tillage of soil, dairy farming, production, cultivation, growing and harvesting of any agricultural.
That is agriculture. Okay. So according to you, employment in any plantation is in the schedule. Now, whether they are skilled or semi-skilled, how it will be decided?
Lordship, there were earlier notifications. Lordship, I'm not sure on that part. Lordship, I need some.
Okay. Okay. See, here only adding or according to you, nothing can be added by way of an amendment or by the notification under 27. That can be done as per
The wages can be increased or decreased. Lordship, new category of work cannot be.
new category of work cannot be done. Now, where is the defined skill, unskill, etc.? How that is to be defined?
That I'm not prepared with.
Who will appear the state? Who will represent state? Gokoi.
S. Sharma being appears for SO number 1 and 2. S. Sharma for labor and.
S. Sharma means? Who is S. Sharma for labor and employment? Now let us once again see the notification, impugn notification.
Page 54.
Now, how is this categorization done? That is we want to know.
Okay, we are saying that this is completely without jurisdiction.
You are saying, is there any scope? Now, we know that there are skill, semi-skill, unskilled categories are there. How this categorization is done?
Okay, if I may take your document to section
Section,
5, sorry.
section 5.
Okay, this talks about fixing of minimum wages for and the
Just a minute, just a minute. Section 5, minimum rate of wage.
merit.
Okay. Procedure fixing revised minimum wage.
This case, Lordship, this fine.
No, this is minimum wages, rate of minimum wages, but minimum wages will be different from different categories.
But-
I want to know where is the categorization? Who will do under what procedure? Huh? Here is this case, schedule is under the schedule, part 1 schedule, there is no categorization. Only inclusion that these people will get protection under or say wages under minimum wages 1948. Now, according to you, they are already there. By the notification, what government is proposing to do is they will now be treated as semi-skill. There is no scope in the schedule to be semi-skill or not semi-skill. Is there any categorization in the schedule? You may be correct on that. That where is the question of this categorizing under 27? But will that wipe out the right of the state to categorize some unskilled subsequently to be skilled in the changing time? Or this act is so rigid that whatever in the schedule, so therefore we want to know what is the procedure of categorization, skill, semi-skill, unskilled. Government may.
The state Lordship, and para 11, there's a mention of a notification dated 11/3/50.
Para 11 of?
The rate petition.
Okay.
Okay, where it is written that earlier in the notification, maybe that particular skilled and unskilled might have been defined. But I'm not sure.
Paragraph?
11 of page 12, para 11.
Page 12.
Talks of a notification.
Any notification annexed?
Not an next.
What is
Next.
Lordship, it is there.
page 27?
23 is the type of
Third in part, list this matter for further hearing on Tuesday. Come prepared. These are the questions. Your whole case, we understand that in exercise of 27, there should be an addition to the schedule only. Okay, we are already on schedule, in the schedule. These employees are already in the schedule that under tea plantation. So there is no scope under section 27 to create or make a categorization skill unskilled. So if that be so, next question would be, will the government be powerless to change the category of skill or unskilled? Isn't it? Even if we upheld your contention. Gogoi, showing name of Mr. Gogoi. Huh? Go through it. किमान मीटर से? No. On 5th. This, our quarter, we will not be taking up this bench. Earlier, you look into the. Okay, we'll see. Be prepared.
I'm applied.
Huh? We'll give you a patient hearing, but we'll not adjourn it on the on basis of the
I'll come
senior is not there. If you can arrange, that is well and good. But 2015 matter will not. 5-3. Hard in part.
Applied.
You are Mr.
Peter.
Peters, hard Mr. Peters. At some length. Is this matter on fit for further hearing?
I'm sorry, that 19 amendment, subsection 4 and 6 has been.
We are in a,
I'm sorry, my lord.
both of us, this young.
No occasion arises.
But that's why I was also overlooked that, but this was in my mind. Then there is no problem. Yes, what is this?
This is also upon my arbitrator, my lord. There's a clause, my lord, in the agreement, which is at page 16.
Yes, who is appearing for this?
In fact, nobody appears, my lord.
No, some B. Boishaw, Learned Counsel Services, C may be given 2 weeks time to file affidavit in opposition and states that Wakalatnam on behalf of.
My lord, once time, and anything, my lord.
Anything
Took time, but no Wakalatnam has been filed.
Wakalatnam on behalf of N.A. Singh. Learned Counsel for the respondent 1 will be filed during the course of the day. Who is respondent number 1?
Persona 1 is the lordship that Basu Simrai.
My lord, that's the contract.
The main contractor under whose they have.
What is the issue, Mr.
My lord, yes, my lord, we have done the work, my lord, on behalf of the main contractor. We have issued
This arbitration is between whom and whom?
My lord, contractor and subcontractor.
Between contractor and subcontractor. Who is the employer here?
My lord,
Where is the contract?
my lord, yes.
On the basis,
Page
where is
16.
page 16. So this is between Timli Bogam.
Yes.
Who is Timli Bogam?
He is representing, my lord, this again. Basu, my lord, lead partner Basu.
So you had a contract with.
Basu Simrai JB. JB.
Okay, Basu, they are respondents here.
Yes, sir.
Okay, Basu Simrai.
JB.
Basu Simrai JV. Okay. Now entered into geo contract infrastructure.
Yes.
For what purpose?
Well, for doing the work on their behalf.
Doing the work on their behalf. Now, where is the arbitration clause?
Yes, well, page 18.
Page
18.
Page 18.
The last one. All dispute relating to the agreement will be mutually settled in case of any difference. The same will be decided by arbitrator in accordance with the provisions of Indian arbitration and constitution. Jurisdictional court will be at home.
Now, what happened thereafter?
Thereafter, my lord, they have not paid the amount. My lord, we have done the work. So we have issued the notice under section 21. That is at page 20.
Page 21.
Property posted page 25. My lord, any charge.
Now, what do you say about the arbitration clause? Is it a valid arbitration clause?
Yes, hello. Because that's very clear.
In
accordance to Arbitration and Concession Act 1996. Will be decided by the arbitrator in accordance with the provision.
Let's read it once again.
Well, page 18.
What was the judgment? What should be the requirement of a valid arbitration clause?
Perkins, your lordships, if I may interfere.
Huh?
Perkins Limited, your lordships.
Let's Well, our scope is limited in section
Appointing an
11.
But other things are to be decided by arbiter. That's section 7. Section 7, okay.
Arbitration council. Who is B. Boisha, Mr.
Well, he's the junior to an annex.
Why Annex is not appearing? He
I
may
don't know
say
why.
that it's a young council. He may say that I have
Well,
not.
he is also my lord working with me, but yeah, it was my lord case was come, nobody had come. And no, well, no, I didn't.
Section
7, subsection 2, my lord. Maybe in the form of an arbitration clause, in the contract or in the form of arbitration agreement.
Okay.
Document signed by the parties.
Okay. Okay, we'll come back at 2. Okay. How many meters are there? Huh? Huh? Okay.
Another arbitration, my lord, matter, other side quickly. He agreed, my lord, then you put it.
You are agreeable?
Respondent.
Huh?
In that case, he 27.
Respondent number? Item number?
27, my lord.
This is item number?
This is item 24.
Okay, we'll dictate at 2, otherwise you will be here. At 2 will 9 admission matrix and here. Which one is this, Mr. That?
That just follow before lunch.
Okay, okay. Geotech. Heard Mr. G. N. Sahala, learned senior advocate. Now, who will be the?
See, we have no rule.
You have
because
no,
it
there
is
is no,
not
it
a-
is
it
no,
is-
no dispute between you also.
It is not an agreement between us.
Us
also.
also.
So,
It's a dispute between him and the respondent
because
number.
even lordship that sub-contact part also, it is not our knowledge also. Lordship. Even lordship that also seem to have violated the terms and condition of tender. also.
Lordship. That is not your local. They say
Lordship.
that we have a joint venture. Now, whether you have paid pay amount to money to him or he is entitled from them, you
That
are
part-
nowhere. We'll clarify that.
Lordship.
But who will be the arbitrator? And we need a consent to nowadays, isn't it?
The list is there. Lordship. Our High
What is
Court
the
list
list?
is there.
List is there because
is-
this bench is not taking up all these
List is
matters.
there,
List is
Lordship.
not.
Written list is there.
What to do, Mr. Saira? Tell us. We will give a chance to them for fixing a next date next week, or with an observation that since none appears, we'll proceed expertly.
In the meantime, also, if they wanted to well, settle the matter, they can settle it.
Hmm.
Can appoint, but anybody will have to from the anybody.
What is the list? List is there.
Written list is there.
Okay. Okay. Just a minute. Just a minute. Let us go to the next matter. Wait for something.
So these are-
But should we deliberate on the since no objection is there, deliberate on the
Any retired High Court judge also, my lord, can be appointed.
okay. No, no, just will just there are some other matters unlisted and all. We'll just complete those matters and fix it.
Your Lordship, I appear for item 25. Are you taking that up, Your Lordships, right now?
Just a minute. Just
All
a minute.
right.
We have called 19 only. Yes, where is Gogoi?
See, I have received lordship certain instructions, lordship. This says that lordship. And they also, apart from they informed there is an interim arrangement lordship for smooth distribution of the lordship that serious item lordship. It's a agent good lordship. Otherwise.
What is the sanction and authority of this good under law?
That is not.
Hard, yes.
Otherwise, lordship, if lordship interfere, I have no objection, then lordship may take with other two. Because lordship, the previous items should be get
See,
to the
here order will be subject to what Mr. Khan says.
lordship.
You proceed with,
No.
but you cannot allow to run the business through a non-entity and an
Lordship.
organization nor non-recognized under law. Prima facie you are satisfied.
Lordship.
Registered agent lordship. I have the agency lordship trade license.
Who is registered agent?
Responsible number 6 lordship. And they from
What is this goat?
they from the there
Is it recognized under the law?
that is the lordship. I have not found that.
So then let us not waste time.
Well, that's one thing lordship, another one thing.
There is no one thing.
But
There is only
how-
one thing, that the deputy commissioner has all right to suspend if there is a complaint, no problem on that. Deputy commissioner, however, is bound to issue a notice for before cancellation and give a reasonable opportunity of higher hearing. That stage has not come as yet. But at the same time, deputy commissioner cannot allow an entity not recognized under law to run a business of this cooperative society or PDF. As simple as that.
Well, that can be. That's one thing lordship I have to point out.
Mm.
Out of 9 lordship petitioner, 4
We are not here taking up the who votes who in whose favor.
4 petitioners have already been arrested. That's that point. Anyway, lordship, your lordship.
Heard. Mr. M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. Khan, learned counsel, appearing on behalf of respondent number 66 on caveat stands research. Also heard Mr. K. Gogoi, learned counsel representing the state respondents.
Time for 1 to
1, 2, and
3 lord.
3. The petitioners claiming to be the shareholders and retail owner and
Members of board of directors.
and members of board of directors of Doloi Gaon GPSS Limited. Full stop. Where is the impugn order?
Page 47.
Page
47. Last second. Before the last.
Page 47. This is impugned. This is impugned here.
Yes.
Members as well. They are agreed by an order dated 20/01/2024 passed by the District Commissioner Morigaon, whereby the PDS sub-wholesales license issued in favor of Messrs. Doloi Gaon Panchayat GPSS was suspended with immediate effect. Full stop. The grievance of the petitioner is that the entire exercise has been carried out by the district commissioner at the behest of respondent number 6. According to them, respondent number 6 is the
President's son. Son of the president.
respondent number 6 is the son of the ex-president,
No lordship.
son of the president of the
Board of directors.
board of directors of the society. Full stop. It is the further allegation that the president was involved in malpractices in the in running the society, and while suspending by suspending the impugn suspending the license of the Gao Panchayat Samabay Samiti, therefore, a direction was issued to run the business of the society through what is this?
Respondent number
Respondent number 6.
Lord.
What is the name?
name is, this is the Azen good, but his respondent number 6 is Atikul Rahman. He is Atikul. Atikul Rahman.
ठीक है लास्ट तक नहीं was issued to run the business through of the society through one Doloigao Samabay Samiti agent গুটৰ পিছত লিখক group agent group good বুলি দি group full stop what is that rule Assam
Under the APS Assam Public
distribution order
not here. Under the Assam Public Distribution of Articles Order 1980.
the Assam public distributions of article orders 1982 empowers the district commissioner to suspend and cancel licenses in certain circumstances. Full stop. Though there is no prescription of giving opportunity of hearing so far relating to the exercise of power of suspension. However, for cancelling a license, a reasonable opportunity of hearing is to be given to the licensee in as much as such notice is required to be given within 90 days from the date of suspension. Full stop. Here, in the case, the date of suspension was 21/20/24, and the 90 days period has not yet been over, and therefore, so far relating to the violations of principles of natural justice, the said right has not yet matured. Full stop. However, this court, when the matter was taken up at the first half, this court requested Mr. K. Gogoi to obtain instruction as regards the legal standing of Doloigao Samabay Samiti agent good represented by respondent number 6. Full stop. Mr. Gogoi has obtained instruction and submits that the said organization is a group of some agents under Doloigao Samabay Samiti. Doloigao Come on, full stop. The learned counsel appearing for the caveator has not been able to send so any provision under the Assam Public Distribution Article Orders at 1982 that the public distribution can be entrusted to a good as a good within bracket group that has been created and that has been entrusted in this case. Full stop. Inasmuch as in the prima facie view of this court, such entrustment is totally against the principle and advices under the public distribution order. Full stop. Having the aforesaid prima facie satisfaction, the impugn order so far relating to continue with the distribution of the public items through Doloigaon Samobai Samiti as an good represented by respondent number 6 shall remain suspended. Full stop. The Deputy Commissioner Morigaon shall be at liberty to ensure the distribution through any other GPSS. Full stop. GPSS. Full stop. Uport issue notice দিব লাস্টত দিব it is made clear that pendency of this petition shall not be a bar for the Deputy Commissioner Morigaon to proceed with the allegation made against the petitioner and in accordance with the public just give the distribution. Give that.
One correction was made. Board of directors, they should be members and president.
Members and president, not board of directors, members. You are the members. You are the members. Members. Instead of board of directors, it will be members. There are some members. He has taken away some members. So his father is not coming in the face, and therefore the caveat has helped him.
Oh my God.
Otherwise, we would not have said this.
All right.
You should be thanks to Mr. Khan.
Maybe the matter has not been complied with.
Uh-huh.
Has not been complied.
Yeah, I mean, subject to the client confirming, because they may have the
What is this?
It's a contempt petition. And on the last occasion, Lordship,
Who is this respondent? Huh?
the Deputy Commissioner.
Please this matter before any other bench without me. Diganta Bora. Same. Same.
Applied.
Item 51.
Yes, Ritu. That affidavit has come, na? Okay, it is similar order here, Korish already. It was along with some other orders. Item 50 already order is passed, similar. Similar, already dictated, I've signed it. Yes.
Item 53.
Yes.
This matter become infrastructure.
You are Mr.
A Bora.
A. Borua, Learned Counsel for the petitioner submits that the writ petition, writ petition has become infructuous. First up, Mr. D. Nath, Learned Senior Government Advocate is present representing the respondents. Full stop. In view of such submission, this matter stands closed being infructuous.
The
Interim order, if any, stands vacant.
sorry, that stay has affected us for last 2 to 3 years.
Okay.
Actually, my
Next. Oh, it is really matter.
But I have seen that panel, my lord, is not the same, my lord, because only 2 our High Court judges name is there in the panel, my lord, based on court of August. Other 6 Supreme Court judges and 4 district judges.
Whom? District judges or Supreme Court judges? High Court judges?
High Court judges only 2, HM Sharma, CS Sharma. Anybody can be appointed, my lord. It is not that, my lord.
Not necessary from the group.
So anybody can be appointed.
Heard Mr. G. N. Chawla, Learned Senior Counsel, assisted by G. Todi. G. Dugar. G. Dugar, Learned Counsel. Also heard Mr. K. Gogoi, Learned CGSC. Full stop.
I am for 2.
Respondent number 2. Full stop. Respondent number 2 is having no role in this arbitration petition, in as much as the claim of prayer for appointment of arbitrator has been made in terms of an agreement / contract entered into between the petitioner and the respondent number 2 and respondent number 1 and the respondent number 2 is not a party in the aforesaid contract. Full stop. Though notices were duly served upon respondent number 2 and respondent number 1. And Mr. N.A. Singh, Learned Counsel, made a submission on 8/1/2024 that he has instruction to appear on behalf of the respondent number 1 and subsequently sought for a time to file affidavit on 29/1/2024. However, none appears for the said respondent number 1, nor any affidavit has been filed till date objecting the prayer for appointment of the arbitrator or raising any objection as to the validity or arbitrability of the dispute raised.
Even though, like, no,
Anyway, let us be there. Okay. Full stop. The office note. Office note dated 24/1/2024 also reflects that the registry has not received any wakalatnama on behalf of respondent number 1. Full stop. The grievance of the petitioner is that the petitioner and the respondent number 1 entered into a contract. Where is that?
well, page 16.
Entered into a page 16. Entered into a contract for execution of certain contractual work, and accordingly, in terms of the said contract, the petitioner has executed, performed his part and completed the work. However, no payment has been made to the petitioner. Accordingly, the petitioner issued issued a notice under section 21 of the Arbitration and Conciliation Act 1996 read with the arbitration clause of the agreement dated 18/12/2020. It is further stated that said notice was duly served when said notice was, where is the notice, service of notice? That is an important aspect. Where is the statement? No statement, Mr. Sarala.
Then receiver also.
Annexer is there, 2211.
Yes.
Though the petitioner had already invoked the arbitration clause, requested however, the respondent has restrained themselves from. Huh?
Access is there, not receive is not there.
Where is the annexer?
It's an page lordship, annexer 3 lordship.
Page?
Page, probably the page number is not given in my application. Last lordship.
This is the notice under 21.
Lordship.
But where is the anything, any receipt, registered post,
Nothing is there.
nothing is there.
Nothing is there.
But their counsel appeared.
Nothing is there. Lordship.
That is where now.
Well,
But first satisfaction is yours. Just a minute. Fine.
that is not there.
Not there, not absolutely a single statement. Where is the? Okay, Mr. Sahala, Learned Counsel for the Learned Senior Counsel submitted him granted some time to file an additional affidavit to bring on record when the demand, when the notice demanding invoking arbitration clause was served upon the respondent number one. List accordingly. Yes, next.
Your Lordship, I appear in item 25.
Yes.
I appear for the petitioner. This is also an arbitration petition, Your Lordships, a Section 11 petition seeking appointment of an arbitrator. Your Lordships, what has happened in this matter is that this matter has been now pending for the past 1 year. The issue here is that the arbitration clause basically envisages appointment of arbitrators by the railways from a panel of arbitrators. Now, Your Lordships, the Supreme Court has repeatedly held that a person who is ineligible to become an arbitrator also cannot appoint an arbitrator, and a person who has a close relationship with any of the parties to the arbitration also cannot, by that logic, appoint an arbitrator. So, Your Lordships, the only problem, the only issue that the respondent likely is going to also urge today in today's hearing is that there is a 3-judge bench judgment of the Supreme Court, which essentially has held that there is no anomaly when the appointment happens within the railways. Now, Your Lordships, I would quickly like to point out one recent judgment of this honorable court. My colleague who is there in the court is going to hand over a copy of this judgment. This is a order dated 5th of February 2023. Now, in this particular order, the Guwahati High Court has proceeded towards the appointment of a neutral arbitrator. If Your Lordships has a copy of the judgment, I'm very yes. If Your Lordships takes a look at paragraph 3 of the judgment. He accordingly submits that this court should appoint an arbitrator as the arbitrators that have been proposed by the respondents are their own railway officials. This is exactly the fact situation in our case. The arbitration clause at page 66 also envisages a similar mechanism wherein we have to basically choose from a panel of 4 arbitrators, and then the railways will decide which out of those panel members will become the arbitrator. Now, if Your Lordship is kindly pleased to come to page 7 of this order at para 11. The Guwahati High Court has relied on the Supreme Court judgment in Perkins Eastman to proceed with the appointment of an arbitrator while holding that railways cannot appoint their own persons as arbitrators. If I may please read this particular paragraph from this short order. Thus, as per Section 12 of the 96 Act and the law laid down by the Supreme Court in Perkins Eastman, any person who falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. Further, a person who is statutorily ineligible to be an arbitrator also cannot nominate a person as an arbitrator. Keeping in view the judgment of the Honorable Supreme Court in the case of Perkins and the fact that the application for appointment of a sole arbitrator has been made subsequent to the amendment of Section 12 of the 96 Act, this court is of the view that a railway official cannot be appointed/nominated as an arbitrator as he is an interested person. Now, Your Lordships, we are relying on this judgment today before you and seeking the appointment of the arbitrator in my case. The problem is that the delay in the commencement of these arbitration proceedings because of the pendency of one judgment of the Supreme Court, which honestly has no end in sight, and we don't know when that matter is going to be listed, has completely crippled my clients financially, who are small contractors and who cannot wait for the constitution of a larger bench to resolve that particular issue, Your Lordships.
That central organization.
Correct. That is that. So a 5-judge bench has been constituted, but there is no next date in that particular matter.
5 judges bench. What is the reference?
The reference, so central organization, that judgment has been, the correctness of that judgment has been repeatedly
Correctness of which judgment? Correctness of which judgment?
CERC, Central Organization Judgment, Your Lordships. That 3-judge bench judgment, there is a line of judgments which basically say that railways cannot appoint their own persons as arbitrators. However, the problem is all of those judgments are in combinations of 2.
Now, according to you, you will argue this, that though there is a reference, the law holding the field will be the applicable till the judgments are reversed.
Correct.
So therefore you say that it should be also proceed. It cannot wait till the decision of the
Absolutely, Your Lordships. And Your Lordships, in fact, this honorable court on the previous occasions had given ample time. The reason this matter was adjourned was with the understanding that the five-judge bench is going to be constituted and a decision is going to be rendered. But no one knows when that decision will come into play because the bench has not even been constituted, let alone a
Now,
date
what
in
is
that
the
matter.
provision when a matter is pending before a larger bench, but already law is there? Which one will follow?
Your
Will the
Lordship,
legal process should proceed?
today there is ample precedent before you to follow, including this recent judgment I have cited before
Yes,
you.
Gogoi, what you say?
Lordships, the judgment which was referred to the larger bench, the Attorney General has appeared last occasion.
No, that we understand, but there may be, matter may be referred to larger bench, that may be pending.
Lordship,
Is there any state that no?
no, Lordship, no. The law laid down by the Honorable Judges Bench of the Apex Court is still today in.
Which is the judgment?
That is the Central Organization of Railways, Lordship.
What is the judgment says?
Paragraph 36 and 37, Lordship.
What it says?
It says that as per GCC, we can, Lord.
Your Lordships, there are judgments of the Delhi High Court and judgments of the Guwahati High Court, which has differentiated this judgment.
Because I am doing one case, my lord, which is pending. Here, what happened, my lord? That matter has been referred to larger bench. We have, my lord, got a stay of the artificial tribunal, which is posted as part of the clause. Now, in the meantime, my lord, some other cases were there. These also went to the Supreme Court. In Supreme Court, my lord, bypassing that, said that we should have wait, we shall appoint arbitrator. Accordingly, my lord, the judge was Court has been appointed. Today, my lord, I don't have those copies, my lord. But Supreme Court has appointed 3 cases, my lord, 3 judges is separate.
Your Lordships, not only the Supreme Court, several high courts across the country.
No, according to Mr. Gogoi, which is the law holding the field?
Lordship, this is the law holding the field at present, Lordship.
Which is the law?
Central Court.
Where is that order?
Central Organization, that is there.
That is civil appeal.
There is no conflict regarding key judges bench judgment, Lordship.
No.
There is no conflict.
This is an order where Central Organization for Railways Electrification, which says matter is adjourned. Okay. Now, what is the law? What is the reference in this case?
Reference is that, Lordship, another case is the Kantia construction.
Where is the
Kantia construction reference is placed in the, Lordship, one arbitration petition order is there in the file, Lordship. Arbitration petition 4 of 22, Lordship. In the Kantia constructions, the law laid down by the Honorable Judges Bench of the Apex Court. In the Central Organization case, there is some doubt, Lordship. Because the Tantia constructions views that it should be, Lordship, placed before the larger bench. Accordingly, Honorable Chief Justice of India has constituted a larger bench, and it matter was, Lordship, remanded there, Lordship.
Your Lordship, if I may intervene here.
So, Central Organization for Railways Electrification 2020-14 SCC 712.
Lordship.
That has doubted correctness of which judgment?
No, Your Lordship, this is not correct.
That judgment correctness was doubted by the Lordship Tantia.
Okay.
And so, Lordship, the matter was referred to the larger bench, and larger bench, till today, not interfere, not state the, Lordship, findings of the key judges bench of the Honorable Apex Court.
Your Lordship, what has essentially happened in the Supreme Court is that in the Supreme Court, a statement was made by the Attorney General to suggest that they want to essentially bring about overall changes in the Arbitration Act, including reviewing this particular decision. Therefore, the Supreme Court firstly has not set any date when this particular constitution bench is going to sit.
No, that we have seen.
As a result of this, Your Lordships, what has happened is a lot of these clauses, a lot of these pathologically worded clauses, where the railways want to appoint their own arbitrators, the contractors are suffering, Your Lordships. So some view has to be taken today.
We'll come to that. Just answer me 3 questions. First of all,
I will also try to explain to Your Lordship as to how under law, under the Arbitration Act.
Let us come to the fundamentals.
All right.
Okay. Instead of going here and there, let us come to the fundamentals. You are relying on the judgment of this court in, where is that? Just now he has relied on.
This is a short order, Your Lordships. Bharatiya Doors versus
Bharatiya Doors.
Correct. It's an order dated 5th of Feb 2024.
Now, dear, what is the principle in Parkin's instrument?
Your Lordship, the principle is fairly simple. Somebody who is
that we have said.
Correct.
Now, any conflict between Central Organization for Railways Electrification, that is 2020-14-712, or Eastman?
Your Lordship, the conflict is this, that the arbitration clauses in both of these cases were different. In
Okay.
Perkins, what had basically happened was the managing director of the respondent company was given the power to appoint an arbitrator.
Okay.
There, the Supreme Court said that because the managing director is himself ineligible to become an arbitrator, that ineligibility also gets attracted towards appointment. This is under Section 12, read with the 7th Schedule of the Arbitration Act. Now, in the second judgment, in the central reorganization judgment, what essentially had happened was that the claimant was given an opportunity, claimant was given a pool of arbitrators to select from. This pool essentially comprised of retired railway officers. There, the Supreme Court said that because a pool has been provided, it cannot be said that this pool essentially is going to be biased towards one particular party.
So, basic fundamental principle of Perkins Eastman is the bias. Because you cannot be judge of your own case.
Absolutely.
Absolutely. This is the principle in Perkins, that you cannot be judge of your own case. Therefore, in that case, it says that yes, arbitrator cannot be. But in case of Central Organizations for Railways, it relates to railway, and there is a panel of arbitrators they have offered. Now, Supreme Court says it will not be unbiased. So, what is your problem in appointing arbitrator and following Central Organization for Railways?
Your Lordship, the problem is that even this particular panel is not broad-based. There are subsequent judgments of the Supreme Court and the Delhi High Court who, while they may not have directly gone against central organization, but they have held that in order for a certain panel to be a valid panel, this panel had to be a
judgment. Show us a judgment after Central Organization for Railways by Supreme Court dealing with central organization and saying that though there is a panel, but that panel will be a bias.
Your Lordship, I do not have a Supreme Court judgment on this, but there is a Delhi High Court judgment which has differentiated this particular this exact point and proceeded with the appointment of the arbitrator on the ground that the panel was not broad-based.
So, in Delhi High Court judgment, do you propose to say that central organization was dealt with?
Yes, yes, Your Lordship.
Dealt with, and it was clarification was made that central organization of electrification shall not be applicable in each case.
Yes, Your Lordships. In that judgment,
therefore, which one is that judgment in Delhi High Court?
Yes, Your Lordships.
It goes by the name of Margo Networks.
I will just give you the paragraph numbers in 1 second, Your Lordships.
Yes. So therefore, later judgments pendency, let us not go to that. We'll go whether whether this principle in 2020 is laid down in 2020 by the Honorable Apex Court has been clarified in Delhi High Court judgment in Margo.
Yes, Your Lordships.
What is the ratio laid down? This is the first. And second part is whether we accept that principle.
Agreed.
Whether Delhi High Court can rectify or
no, that is a different issue. But second issue therefore is whether that is not a binding precedent on us. That is having a persuasive value.
If Your Lordships has the judgment in Margo.
Yes.
Yes, Your Lordships. Your Lordships may kindly be pleased to come to paragraph 41 at page number 23.
Page 41.
Correct.
Yes.
Before that, if Your Lordships may kindly be pleased, 1 second, Your Lordships.
Where is the discussion as regards railways?
Yes, Your Lordship. Yes, Your Lordships. Can Your Lordships kindly come to paragraph 25 first at page 15?
Page 15, paragraph 25.
Correct. Now, Your Lordships, this discussion is on core, which is the central organization judgment, and also a prior Supreme Court judgment, which essentially had the same facts. And I'm reading from para 25. Thus, it was held by the Supreme Court in Wallace Fine that affording a panel of 5 names to the petitioner, from which the petitioner was required to nominate its nominee arbitrator, was restrictive in nature. The same created room for suspicion that DMRC may have picked up from its own favorite. In our case, only 4 names have been given. Delhi High Court has held even 5 names to be Supreme Court has held even 5 names to be restrictive.
Okay, proceed.
Choice should be given to the concerned party to nominate any person from the entire panel of arbitrators. The 2 arbitrators nominated by the party should be given full freedom to choose the 3rd arbitrator. The panel ought not to be limited to retired engineers, which is our case, by the way, and or retired employees, but should be broad-based and apart from serving or retired employees of government departments and public undertakings. The panel should also include lawyers, judges, engineers of prominence from the private sector. This is, Your Lordships, the Supreme Court saying in a judgment after court. Then, Your Lordships, if you come to para 26, the Delhi High Court says, Court does not in any manner overrule the earlier Supreme Court judgment or narrow down the scope thereof, although it does not deal specifically with the issue as to whether the panel afforded by the railways in that case was in compliance with the principles strictly laid down in Vogelstein. In the present case, if Your Lordships come to para 26, the respondent has shared a panel of 10 arbitrators with the petitioner, all being ex-employees of the railways. Apart from the ex-employees of the railways, no other person has been included in the panel. Such a panel is clearly restrictive and is manifestly not broad-based and therefore impinges upon the validity of the appointment procedure prescribed in clause 3.37 of the RFP.
Okay.
Then after this discussion, the Delhi High Court goes ahead and appoints an arbitrator in the face of court.
So basically, this is the interpretation of Delhi High Court.
Correct.
Paragraph 25. Now,
Correct.
where is the court judgment? What is the ratio in this judgment, court judgment?
Your Lordships, I do not have a copy of core handy with me, but I believe the opposing counsel has a copy of core.
That is 2/2020. Which are the paragraphs?
Paragraph 39, Lordship, very specific 39 and 50. Lordship.
Now, this core was doubted in which judgment?
Core, Your Lordships, has been doubted in 3 judgments of the Supreme Court. Core has been doubted in Perkins, core has been doubted in TRF, core has also been doubted in Tantia Constructions. Tantia Constructions is a short order of the Supreme Court rendered in 2020.
Also, they are lost in the file, Tantia also.
Wherein the Supreme Court had specifically said that
Doubted in
Tantia core has been doubted in Tantia Construction versus Union of India. It's a short order.
Then and other which
in Perkins, in TRF and Tantia Constructions. If Your Lordships,
Perkins 2016 Lordship.
if Your Lordships is kindly pleased to take my petition, my petition lists all of this. Page 16.
Where is Tantia?
Tantia, one copy is probably in the file, Lordship. Not
Could
much.
you pass over a copy of Tantia Construction to Your Lordships, please?
Tantia, nothing is there. Just 1 page from their Lordship.
Where is Perkins judgment?
Perkins Lordship 2020, it cannot be doubted.
Your Lordships, yeah, he's right. Tantia is the judgment where the correctness of
Tantia,
has been
any
doubted.
citation of Tantia?
Tantia in the file, Lordship, I have given, Lordship, but there is no any observation, no any interference regarding, Lordship.
Your Lordship, the citation would be, it's SLP civil number 12670 of 2020. I do not have the SEC citation handy with me right now, but the citation as appears from the reportable judgment is SLP civil number 12670 of 2020. It is an order dated 11th of January 2021.
Only 1 page, Lordship, only single pages is loading. Only they have doubted the principles of law laid down by the lordship.
Your lordship, the point
Just
still
as go through,
remains.
these are the judgments in.
Your lordship, the point still remains. I am not contesting the fact that core is a judgment which holds the field. I am not for once arguing on that principle that your lordship should not follow core.
Just a minute. Okay.
Your lordship, if I may be permitted to wrap up my arguments, I am not for one suggesting that your lordships should not follow core. All I am suggesting is that in the presence of core, there are several precedents before you. There are judgments of the Delhi High Court, of this Honorable High Court, and in fact the Supreme Court, which has not only doubted the correctness of core, but gone ahead and appointed arbitrators.
Where are those judgments of Supreme Court? Tell us. Forget about Delhi High Court for time. Tell
Your
us.
lordship, if you reopen the Delhi High Court order, the order in give me 1 second, your lordship. If you come back to the Margo order, your lordship, at page 14, para 25.
Just a minute. Page, paragraph?
Paragraph 25, your lordships, at page number 40, at page number 15. So, Wolfenstein was a judgment which was rendered before core. It is not a judgment after core. But the principles in Wolfenstein have clearly been differentiated from that in core. I am not saying that the Supreme Court
Where is the
judgment.
citation of this judgment?
Yes, your lordships. I'm just giving it to you.
Because that is important. We'll have to also have a
Absolutely, your lordships.
To concur with the view of Delhi High Court, we'll have to go through that judgment.
Absolutely, your lordships. I'm just giving it a citation.
The bottom line is 2017 Ford SCC 665.
2017
Ford SCC
4 SCC, give a copy and
65.
Huh?
665.
665. Okay.
Correct. Yeah. 2017 4 SCC 665, your lordships.
Okay. Okay. Now you proceed. What you want to say?
Your lordship, my submission is fairly my submission
You want
is,
to say something regarding this judgment?
yes. So this is also a judgment where a similar panel was introduced. And what the Supreme Court here said is that in order for a certain panel to master the tests of independence and impartiality, which are the cornerstones of Section 11 of the Arbitration Act, then such a panel has to be a broad-based panel. Assuming that panel is something that we have to go by, it has to be a broad-based panel. It cannot just comprise of retired railway officers. And it has to be a panel that is going to give enough, that is going to alleviate the concerns of partiality and biasness that one side may have. Now, if your lordship looks at the arbitration clause in the present facts, claimant only has the option of choosing from 4 retired railway officers.
Okay.
Let us take a look at the arbitration clause in the present facts for once.
Yes.
Page 66 of the record. At page 66, clause 64 3B2, which is basically the third paragraph at page 66.
Page 66 was B2 or C2? I am at page 66.
Yes, the third paragraph at page 66, Roman 2. In
Contractor will ask.
Yeah, after that, your lordship, Roman 2.
In cases where?
Correct. In cases where the total value of all claims in question added together exceed 50 lakhs, the arbitral tribunal shall consist of a panel of 3 retired railway officers not below the rank of senior administrative grade officer as the arbitrators. For this purpose, the railway will send a panel of at least 4 names of retired railway officers empaneled to work as railway arbitrators, duly indicating the retirement age to the contractor within 60 days from the day when a written and valid demand for arbitration is received by the general manager. This is a case where only 4 names have to be given. There are cases where 5 has been held to be restrictive.
This is a clause, arbitration clause. It's a contract specific or it's a GCC?
It's a GCC specific arbitration clause, Your Lordship.
GCC
The
of
railways,
which year? GCC of which year?
this is 2018, Your Lordships.
2018.
Correct.
And what was the GCC in core?
The GCC in core, Your Lordship, I'll have to check. I am not sure, Your Lordships, but most likely 2018.
Same clause, same 64 T, B, it is T A 2, same clause. 2018, same. And that clause is in page 65 in this, if you can look it. And for paragraph 39, Lordship relates to paragraph
Now,
page 65 of this
see,
petition.
I understand your argument. Your whole plank of argument is that to wipe out the partiality and biasness, these judgments have come. Firstly, that what is the judgment? Last judgment, where it says that why it should be, principle is laid down. Now, in this judgment, according to Delhi High Court, that principle is not overruled. Isn't it?
Correct.
So that principle is not overruled. Therefore, Delhi High Court relied on the earlier judgment.
Your Lordship, if I may quickly interfere, Delhi High Court obviously cannot in its capacity overrule a Supreme Court judgment.
No, I'm not saying Delhi Court is not overruled. Delhi High Court has said that since this part was not dealt, that principle was not dealt, therefore, there is no bar in dealing with that principle or following the principle laid down in the earlier judgment.
I follow, yeah.
So in that context, a contract relating to a different organization was interpreted in terms of an earlier judgment. Okay, fine, no problem on that. That is a principle and interpretation which is beneficial to avoid a biasness. That is welcome. That is the principle in a adjudicatory process. A judge should not be everything. Now, how do you explain this core when it relates to railway and the same clause, exactly a replica?
Your Lordship,
Principle is fine, but this Delhi High Court case is not a case relating to exactly the same GCC or same clause.
Your Lordship, it may not be exactly the same GCC, but it's only a question of nomenclature. In the Delhi High Court case, the respondent was DMRC, which is the railway metro organization.
But that clause is something different. Here,
the clause may be different.
How this court will say that though because he has raised this point, though this is similar, however, will not follow this, will follow that.
Your Lordship, the clause may be different, I bow down, but the principle in all of these clauses is essentially the same. The principle being, can the railways give a list of arbitrators who happen to be their retired railway officers?
Now, in this core, the principle is like this. What we can understand is, when the agreement specifically provides for appointment of arbitral tribunal consisting of 3 arbitrators from out of the panel of serving or retired railway officers, the appointment of arbitrators should be in terms of the agreement as agreed to by the parties. How we distinguish that no, this principle is not applicable in case? Because there is an argument by them that this is the ratio. That Honorable Apex Court has said that when you have agreed to the arbitration clause, there cannot be any direction. There cannot be any direction to issue a separate. The High Court ought not
with
to
the
have
utmost
decided.
amount of respect, I'll have to submit that mere agreement to an arbitration clause is not the same as suggesting that the arbitration clause is valid. Because by that logic, even agreement to a unilateral clause is going to be valid. In Perkins, however, that rule was laid down. In Perkins, it was held that one party cannot unilaterally appoint an arbitrator, and
Where is the
somebody who has a close relationship.
Perkins judgment, citation?
Your Lordship, the citation of the Perkins judgment
My
is
lordship, the railways central organization case that
2020 SCC 760.
2017 was also discussed, lordship. Paragraph lordship 27 lordship.
2020 SCC 760.
Pace.
The citation for Perkins.
Lordship, in the central organization, it's lordship paragraph 27 lordship.
By the letter is it?
Lordship. That was also discussed in this case, lordship. It's not a case that lordship that his judges bench not discussed the earlier judgment, lordship.
Your Lordship, today the issue is this: because of this one judgment, there are several arbitrations across the country, in fact, which are getting stalled. And it is very, very convenient for the railways and council representing the railways to seek refuge behind this one judgment and say, don't appoint the arbitrator, let the Supreme Court decide. But the problem is, as a result of this, contractors whose contracts have been illegitimately and illegally terminated by railways left, right, center are suffering.
No, what was the answer to this reference contention? Retired railways officers, what is the issue here?
So some view, your lordships, has to take today, keeping in mind judicial committee and also delivering actual justice.
In central railway organization also, lordship, that case, lordship, Honorable High Court has appointed as a lordship arbitrator, independent arbitrator, lordship. That's why Honorable Supreme Court has said that, lordship, as per the GCC clause 64 TB1, lordship, there is specific provision to railway as the authority. Here the appointment of the independent arbitrator, lordship.
Okay. Okay.
Just one last thing, your lordships, I would like to indicate. On the last date of hearing, when this matter was listed before Justice Medhi, in fact, had adjourned the matter on the understanding that the hearing in the Constitution Bench matter will take place. In fact, on the last day, he was inclined to pass upon the arbitrator, but wanted to give the respondent one last opportunity in the hope that some development happens in the Supreme Court. Unfortunately, the last time the matter was listed was in November. And since then, there has been absolutely no movement in that Supreme Court matter. So if your lordships were to wait till that matter, who is going to suffer ultimately are these small contractors. Nobody else. So some view has to be taken, your lordships. The Guwahati High Court has appointed an arbitrator. The Delhi High Court has appointed an arbitrator, despite the presence of a Supreme Court judgment.
This should not be your argument. Come to the substance.
Your lordship, even substantially.
This should not be your argument. What should be your argument?
Even substantially, your lordship.
Central organization, what was the issue?
The issue here, your lordship, was fairly simple.
What was the issue in core?
Whether retired railway officers can be arbitrators.
That was the issue.
Supreme Court said there is no impediment in this.
So therefore, your argument should be Delhi High Court rightly decided that the issue in core was whether a retired railway employee is eligible for appointment or not.
Correct.
It was not an issue which is decided in the earlier judgment where issue of biasness was decided. That is the substantive argument. What happened, what should be prejudiced, that is not, should not be your argument. Your argument should be that two cases are absolutely different. In one case, the issue was whether a retired person can be made applicable, not a question of biasness and not a question of section 12.12. 12.5. In section 12.5, that has been mandated. So therefore, reading section 12.5, in core, it has been said that see, retired officer cannot be biased. Question of biasness so far relating to retired officer is not there. So therefore, the earlier judgment need not be argued or deferred in subsequent judgment. That the issue was totally different. So therefore, your argument should be whether core is pending for larger bench or not. The judgment holding the field is the earlier judgment so far relating to biasness. Now, who will suffer what is not a subject matter for determination.
I bow down your lord. I bow down your lordship.
That should be your substantive.
My argument simply is this. My argument always has been that pendency of core can never be an impediment before this honorable court to appoint the arbitrator, because even
that is not the argument of other side. Their whole argument is that this issue has been settled so far relating to the clause 64 in GCC in core. Your case is that no, it was not the. It is not the certification of clause 64. It was the issue as relates the entitlement of a retired railway officer, whether a retired railway officer will have the biasness.
Agreed, your lordship.
Or he can be qualified. So biasness says no, he is retired officer, he cannot have a biasness, so there is no problem. You have agreed it, so therefore railway has done it. Your argument should be, what we answer is a different. Your argument should be that in core, the question of biasness as dealt in the earlier judgment as well as the judgment in what we call it subsequent that Guwahati High Court also relied on, were not the issue. So therefore, this is not a relevant judgment for this purpose. Isn't it? Okay, anything?
Your lordship, my argument throughout has been that core cannot be an impediment, and I bow down to your lordships. And the other argument that I'm making is actually might sound not substantive, but is actually, in my view, a very, very powerful argument, because ultimately in these situations, justice also has to be a certain amount of substantive justice. Today, my client has been waiting for the constitution of an arbitral tribunal for the past 1.5 years, pending a technical issue.
Pendency or reference to a larger bench will not wipe out what law is holding in the field.
Agreed. Bow down, your lordships.
So therefore, until and unless there is a stay that no, this judgment will not be given effect to. Okay? And suppose there is a conflict of two judgment, we will go by the later judgment, or which is pitch into the case, we will go to, there are hundreds of conflicting judgment, there is no issue. But so far reference that is clear, we can, so therefore that is according to us, therefore that is a settled position. Yes.
Already lordship indicated lordship. The judgment which was referred from our high court lordship, it is the issue of central organization was never discussed in this in lordship arbitration.
So let us first take out the important judgments. One is you are heavily relying on core.
The core lordship.
Okay. Now
core and lordship arbitration petition number 4 of 22 lordship. That was also there lordship. Due to the pendency of that larger bench issue lordship, Honorable High Court, our High Court has not interpreted the matter. It is deferred till lordship final outcome.
No, that will answer it.
Lordship.
That will answer it. We have answered in a earlier judgment in a issue regarding as regards definition of some industrial worker under the Industrial Dispute Act. There were an earlier view which was continuing. Subsequently, that has been doubted and that has sent to a larger bench. We said that is pending in the larger bench, but as on earlier view is holding the field, we will follow that. That part is not an issue.
My argument is that lordship.
Your whole argument is
Paragraph
that
39
your case is squarely covers by the core.
And
core core is the law holding in this
paragraph 39 is still holding the field lordship, and the paragraph 39 is the as per the GCC 64 T lordship at 2 lordship.
This is your whole plank of argument.
Whole argument. And another technical argument.
And your case will be where is the Delhi High Court judgment? Your case in Delhi High Court is that relates to a different something different. So this is not binding. Rather, this central
as
core is
because,
binding.
as because law was already laid down by the Honorable Apex Court, we are bound by that.
And what is this Ashok Sadarangani versus others?
That was, I have not.
That is a judgment where you referred that pendency of a reference does not impede the earlier judgment.
But that
That
judgment
is not a here issue. That
before
will
this court,
come.
that is not
That
an-
will come, Lordship, when that particular judgment was state, Lordship.
Now,
And other technical point is also there, Lordship. I just legal issue. This is the legal issue, Lordship.
okay.
Technical point, Lordship.
Now, where is that judgment citation? We are taking Margot, then core, is that it?
Core. And core discussed,
Your
Lordship,
Lordship may also
all the
take
earlier
the
judgments.
2017 Supreme Court judgment.
Just a minute. Then, where is that our High Court judgment by my Lord Justice Jothang Kumar?
Arbitration petition 5 of 2020.
5 of 2020.
And in that particular judgment, my
And where is Parkins Eastman citation?
Your Lordship, the citation for Perkins would be 2020 SCC 776.
Where is that judgment?
The relevant part is quoted in that Justice Vasan Kumar.
But we want to go through it.
2000. We'll furnish a copy, Your Lordship. 2020
Parkins
SCC
Eastman is
760.
2020 SCC 760.
Okay.
Your Lordship, we take one last judgment for reference. We'll furnish a copy.
Just we are separating this because so
Yeah.
many papers are there. Okay. And then which judgment?
2017 8 SCC 377. We will furnish a copy, Your Lordships.
Okay, you furnish a
That
copy.
was in paragraph 25.
That's it.
The judgment which was rendered prior to core.
Prior to court,
Talks
and that has
about-
been relied upon by the Delhi High Court.
Correct, which talks about how a panel has to be a broad-based
That
panel.
judgment we require.
And that was also discussed by the court.
That was discussed in the.
Discussed by the court. And,
Okay.
and Lordship, one technical point I am.
What is the technical point?
Technical issue is that, Lordship.
The is so far issue relating to who should be the arbitrator or what not, that is that we have heard you.
That part
Now tell us.
one technical point, Lordship.
Yes.
Whether the demand given by the petitioner, Lordship, for constitution of a arbitral tribunal is valid as per the provision prescribed by the State of Arbitration and Conciliation Act. Lordship.
Okay, let us see.
So
that.
for that purpose, my lord may kindly come to the demand notice. Lordship. It is in page 90, Lordship.
এখানে এটা হবে লেখা এটা ক্লিক মারিব সেটু
Regarding constitutional arbitration part, Lordship, already I am not going to it. Just only technical point, Lordship. Whether in the as per the provision prescribed by the statute, it should be treated as a valid demand for constitutional arbitration or not. So,
Okay,
Lordship,
where is the demand?
That is in page 90, Lordship.
Page 90.
Page 90, Lordship. It was issued by my brother Rangan to our general manager, Lordship. He says subject is, Lordship, notice invoking arbitration under section 21, Lordship. And my lord may kindly come to dear sir, I write for and under instruction of my client, Lordship, whether it can be treated as a valid demand for arbitration as per the statute, Lordship.
Okay, what does statute says?
Statute says that, Lordship, section 2H, Lordship, Arbitration and Conciliation Act, Lordship.
Just a minute.
Lordship.
Section
2H, Lordship.
Just a minute.
Lord. Definition.
To its party.
Lordship, party. Party means a party on an arbitration agreement. Lordship.
Okay.
Then my lord may kindly come to section 11, Lordship. Section 11(6), Lordship.
Section
When
11.
11(6), when my lord may exercise the power to, Lordship, appoint an arbitrator, Lordship. It says that, Lordship, where a party fails to act as required under the procedure, Lordship. Now, Lordship, as per the GCC, Lordship, who is the party, Lordship? Party should be the lordship. As per the lordship. Definition clause lordship, it should be the party to an arbitration agreement lordship. Here, the agreement was done between the lordship Piyush Traders versus Piyush Traders and the NF Railway lordship. Not between the lordship. Lordship.
Your Lordship, I'm not exactly sure where opposing counsel is going with this argument.
Rangan,
Perhaps doesn't make any sense, but I have the
Lordship,
answer.
I
ready
have the
if your Lordship
sense,
is
I
ready.
place why I have submitting this lordship.
Just a minute.
I am not interfering, Rangan, please. We go by the statute laws, not beyond that law. As per the golden principles of law laid down by the Nazir Ahmed laws.
Okay, now which one you want to?
Lordship party. Party should be the as per the definition clause, it means party to an arbitration
As per
agreement.
2H.
Two ways. It should be
Okay.
arbitration agreement party, lordship.
Mm.
The solicitor or advocate is not a party in the arbitration agreement, lordship. His lordship giving the learned solicitor is giving the lordship that demand notice, lordship. In I write for an under instruction of my client, lordship.
Where is the demand, provision of demand?
Page
demand
90,
notice?
lordship.
Page?
Page 90, lordship.
No.
Under section 21, he's invoking the jurisdiction.
Okay.
lordship.
Your Lordships, I have to intervene at this moment because I'm appalled by the understanding of the English language by my opposing counsel.
Just wait, Mr.
yes.
Rangan. He is
You know,
arguing.
you
Let
know-
you have
You
completed.
know more, so your sub confusion is regarding our English.
Just wait for a minute. Let him complete your argument. We will give you a
Thank
chance to reply.
Lordship. So, lordship, as per the statute, it should be by the lordship concerned party, lordship, not by the attorney, not by the solicitor, not by the
Okay.
power of attorney holder. lordship.
Okay.
And I am relied one of the principles of law laid down by the Honorable Apex Court in this regard, lordship.
Yes.
Who should be the party in the arbitration proceeding, lordship?
Yes.
Lordship. Paragraph, lordship, 15, lordship.
Paragraph?
2012.
Paragraph?
CC
Paragraph?
496, 15, lordship.
15.
115, lordship.
Okay.
115, lordship. The issue is there, lordship. In that particular case, lordship, award was already passed, lordship. Then, lordship, the service of award that was there, lordship. Then Honorable Apex Court said that whom it should be passed to the party. Then, lordship, paragraph 15. Having taken note of the submission advanced on behalf of the respective parties and having particular regard to the expression party, my lord, may mark it, as defined in section 21H of the 1996 Act, read with the provisions of section 31(5) and 34(3) of the Act of 1996. Here, lordship, it should be, in our case, it is section 11(6), lordship. We are not inclined to interfere with the decision of the division bench of the Delhi High Court.
You read from the expression party. Next page.
Lordship. The expression party has been implied deal with in Taco Tesi Engineering Case Limited and also so and so. It is one thing for an advocate to act and plead on behalf of a party in proceeding, and it is another for an advocate to act as a party himself. The expression party as defined in section 21H of the 1996 Act clearly indicates a person who is a party to an arbitration agreement, lordship. Then, lordship, the said definition is not qualified in any way so as to include the agent of a party to such agreement. Any reference therefore made in section 31(5) or section 34(2), in our case 11(6), lordship, act can only mean the party himself and not his or her agent or advocate empowered to act on the basis of his vocal. On the basis of that principles of law laid down by the Honorable Court, my submission before Honorable Court is that the demand notice which was given by my learned friend for constitutional arbitration tribunal is not as per the procedure prescribed by the statute, Lordship. And in that point, in that line, Lordship, I am relying the judgment, Lordship, that Nazir Ahmed Khan, as well as it was reiterated in the Mohendra Singh case, Lordship, in 2023, Lordship. Right.
Paragraph?
Paragraph, Lordship, 14 onwards, Lordship. Only 2-3 small paragraphs I will read, Lordship. The argument of Mr. Bhushan that use of defined language is not followed by any consequence and therefore cannot be said to be mandatory is not enabled. The language chosen is relevant to ensure that the candidate who is filled up an application form or alone appears a written examination to maintain probity. The answer sheet have to be.
So basically,
It is the law.
that is
the principle.
within inverted comma.
Within inverted comma, Lordship. That is the principle.
Yes.
Here, Lordship, party is, Lordship, specifically dealt with by the Honorable Apex Court, this case, Lordship. It should be by the party who are in the agreement, Lordship. On the technical issue, that is my argument, Lordship. Other point, I am bound by the, Lordship, the law laid down by the Honorable Apex Court in the core, Lordship. Paragraph 39, Lordship.
Where is the provision of demanding arbitration?
21, Lordship.
21, Your Lordships.
21, Lordship.
Yes, read it.
Unless otherwise agreed by parties, the arbitral proceeding in respect of a particular dispute commence on the date on which a request for the dispute to be referred to arbitration is received by the respondent. Only that part. Otherwise, Lordship is invoking here 11.6, Lordship. 11.6 says that if party fails to act, Lordship, and party is defined in section 2H, Lordship. This is my submission, Lord.
Your Lordship, going by this logic, any communication issued by an advocate on behalf of any party in any proceeding is going to be OTOs as per the opposing counsel. I only have a short response to this, and the response is fairly simple. Firstly, section 21 does not prescribe who has to issue this notice. My wakalatnama is on record. I represent the party. Even before I issued my wakalatnama, the notice invoking arbitration was not sent at my behest. It was sent at my party's behest. That is also very clear from page number 97 of the record, which is where I sign on behalf of Piyush Traders. Piyush Traders is a party to the arbitration agreement. Both of us agree. Now, once we agree to that, it does not really matter as to whether Piyush Traders goes ahead and issues the NIA or somebody does it on behalf of Piyush Traders, as long as Piyush Traders has given that authorization. I have that authorization, and therefore there is no impediment in me issuing the NIA on behalf of Piyush Traders.
We have traveled many law. Let us understand the fact.
Sure.
Which we ought to have done first. What is the contract? What is the arbitration clause? Yes.
Your Lordship, this is essentially a contract which was for.
What is the contract first and the arbitration clause?
Yes, Your Lordship. Your Lordships will find the contract at page 23 of the record.
Yes.
This was a contract entered into in 2019. The work entrusted was essentially cleaning and transportation of linen sets to and from the railway premises in Guwahati Depot. It was a contract for 3 years.
Mr. Gogoi, any affidavit filed by railways?
And our
So
Paragraph
basically, basically place 66.
Lordship.
Place 66.
Lordship.
64 3B2.
Lordship.
Is that it?
Lordship. Page 64, Lordship.
Page 66.
66 is where the arbitration clause is.
64.
That is what we want to, because we will not go to the others.
Correct. 65 is where the arbitration clause starts, appointment of the arbitrator. Now, the relevant clause for us starts at the end of page 65 at 64 3B, appointment of an arbitrator where applicability to section 12.5 has not been waived off.
B2.
Before the
64 3B2.
64 A2.
A2, Lordship. Yes. That was dealt by the Lordship court.
That was dealt in the court. similar, that is the, okay. So that is the issue. Yes, Rangan, you want to add something?
Yes, Your Lordships, just simply in response to the technical argument which was raised by the opposing counsel, there is absolutely no anomaly in an advocate representing a party. It does not take away from the fact that Piyush Traders continues to be a party to the arbitration agreement. And the NIA was sent by Piyush Traders, by me on behalf of Piyush Traders. In fact, the stamp and logo of Piyush Traders at the end of the NIA also signifies, also as an indicator to that effect. So I don't want to waste this honorable court's time in this regard any further, but simply say that the first line of the NIA is no longer, does not mean that I have sent the NIA on my personal capacity. It is on behalf of
So
Piyush.
your argument is that
Therefore-
it is nowhere in the prescription in the act that notice should individually be issued by the party.
A, that, and B,
Yeah.
even if there is some sort of indication to that effect, an advocate is never going to be barred from issuing a representation on behalf of the party. And the act of the advocate doing so does not mean that the nature of the party changes under the Arbitration Act. That's all.
Okay. Yes.
I rest my submissions, Your Lordships.
Hearing concluded, list it on 6th of March for delivery of orders.
Oblige, Your Lordships. Very, very grateful for Your Lordship for this patient hearing. This matter has been going on for 1.5 years. This is the longest this honorable court has heard this matter. Very,
The
very
mandate of the section 11 and the judgment, it should be at the earliest.
absolutely, Your Lordships.
Yes.
Very grateful.
Keep it in the chamber. Yes, next case.
Item 26.
May I please, Your Lordship?
Yes.
Lordship, may kindly pass over for the time being, my lord.
Why?
Mr. D. Nath is in like some court number 2, my lord.
Take up some other days. Do you have any objection? Not is having any objection for appointment?
I don't think there should be any objection with regard to that. And in the affidavit also, they have not raised any objection.
Okay, please this matter after 10 days.
He is just coming, my lord. He is just
Wait for something. Wait for something. Yes, next case.
obliged.
Item 27.
You are for?
I'm for the respondent, sole respondent. I'm from.
Heard Mr. G. N. Sahewala, learned senior counsel, assisted by Mr. M. Sahewala. Also heard Mr.
Gupta.
K. L. Gupta, learned counsel appearing for the respondent. The present application under section 11(6) of the Arbitration and Conciliation Act 1996 as amended up to date has filed for appointment of an arbitrator. Full stop. Where is the clause, Mr. Chair?
My lord, yes, that page 50.
Page
50.
50. 50. 50. Any agreed name?
My lord, file and fit also agree, my lord, that any retired high court judge can be appointed. Yes, ma'am. I have nothing. That can be, my lord. He's in the panel also.
Huh?
He's in the panel.
I have heard.
Where is Mr. 50, page 50, Mr. Sir? Page 50.
50.
Resolution of disputes.
So, my lord, some other may be appointed because his daughter is in my chamber, so that.
Okay. Yeah. Okay, that's better.
It is better Justice Ali may be appointed, my lord. My lord said agree.
Lordship,
Who?
M. Ali, my lord.
Okay. He can take, na?
He can take. Yes, he's taking, my lord.
Taking?
My lord, taking.
Okay, very good. Sahewala, so and so. The full stop. It is a case of the petitioner that an work contract was executed between the petitioner and the respondent on 23/3/2012 for procurement of educational services and supply and maintenance of ICT hardware and accessories. Full stop. The estimated cost of the project was 209,74,60,000. Full stop. Certain disputes as regards dispute arose as regards payment and non-payment payment of outstanding dues. Accordingly, a notice a notice in terms of Article 26 of the agreement.
24, man.
24. 20?
24.
24. No, 26 is the notice.
Yes, page.
A notice. Page 51. Notice was under 26.
26.
Notice under clause 26 of the contract was issued. Notice in terms of notice as prescribed under clause 6 of the clause 26 of the contract was issued demanding referral of the dispute for arbitration. Full stop. Though disputes was notified, however, such said dispute could not be resolved. Accordingly, a notice dated 19/1/2023 was issued by the petitioner to the respondent for appointment of arbitrator. Isn't it?
Yes.
Correct, Mr. Sahala?
Correct.
No, we are asking the junior side.
My lord, yes, my lord.
Will not blame a senior advocate. Any mistake will be go to him.
My lord, my lord.
Okay?
Right.
However, when arbitrators were not appointed within the prescribed period, the present petition is filed. Full stop. Notices were duly served upon the respondent Amtron. Full stop. And Mr. KL Gupta has entered appearance on behalf of the Amtron. Full stop. Mr. Gupta submits that submits on instruction that the respondent Amtron is having no objection for redress for resolving the dispute through arbitration as provided in clause 24 of the contract agreement. Full stop. Peruse the said contract agreement. There is no dispute as regards there is no dispute either as to the validity of the said arbitration clause or as to the arbitrability of the dispute. Full stop. Mr. Gupta further submits that if Mr. Mr. Justice M.A. Ali, within bracket, retired judge of this court, is appointed as an arbitrator. Full stop. Mr. Sahal has also submitted that he have no objection if Mr. M.A. Ali, as Mr. Justice M.A. Ali, within bracket, retired, is appointed as arbitrator. Full stop. In view of the, but do you need a consent or you can direct appoint? Okay. Amount is good. As per schedule, there will be no problem. So, in view of the aforesaid consensus, this application is disposed of by appointing Mr. Swencho as arbitrator. Parties registry to communicate this order to Mr. Swencho and parties may appear before the arbitrator on a consensus date to be arrived at between.
Item 26.
Yes, Mr. Nath. Any dispute serious?
In fact,
PWD?
PWD, in our dispute for arbitration.
Okay.
In affidavit, we have said
Mm.
that they are required to, their grievance is that completion certificate has not been given.
Mm.
It is with me. Yeah, already it is given. 3% deduction for forest royalty, that has to be there. They have to submit a document, they will get back there.
Now, if forest royalty is there, then they will have to file a writ petition. Law is settled. Anyway, if not in the agreement,
No,
there is
it
on a
is-
lighter sense.
it is in
So
the- it
have
is
an
in the-
instruction.
It is in the agreement.
Withdraw this. In view of the affidavit filed, this application stands closed.
No, Lordship, the thing is that this,
Completion
You want to
certificate.
spend some more money.
Look,
Completion
ultimately,
certificate is issued.
it is issued now, it is given to them.
no, that I've seen, Lordship, but the fact is that this, notice was accordingly issued, but there's no communication during that relevant period. After filing of this arbitration application, then only this.
No, Mr. Nath is coming, he is a responsible.
No, affidavit has been filed with regard to that.
Affidavit is filed, you make a submission that you, in view of the affidavit is filed, dispute is so and so, so and so, affidavit is filed so and so, so and so. Therefore, nothing survives at this stage. For proceeding in arbitration, we'll close it.
But we have in fact said that this can be settled here itself, by this before this honorable court itself, it can be settled.
Let me
Completion-
get the instruction law.
com-
It will be
completion
taken up
certificate
and
we have given, nothing
um,
is there. If the parties goes to arbitration,
Why
ultimately.
is this some money should be spent? Isn't that state's concern is
That
this,
is- that is-
whatever you want, I
yes,
have
sir.
given you, why should you go?
Interest burden, and he has to give us.
It is
undertaking.
submitted by Mr. Nath, learned senior government advocate, that the dispute raised is non-issuance of a
Completion.
completion certificate. However, during pendency of this application, the completion certificate has already been issued and an affidavit in this regard has also been submitted. Therefore, in view of such stand, no dispute exists as on date to be adjudicated by
arbitration.
appointing an arbitrator. Full stop. The learned counsel for the petitioner submits that he may be granted
Next day,
the
next week.
2 weeks time to obtain instruction from his client in this regard. Full stop. Prayer is allowed. List accordingly after list accordingly on 7th.
It's a expensive business for the state.
Yes, yes.
Look,
Please, your lord.
Lordship, here, although I have not yet received complete instruction, Lordship, for filing affidavit, Lordship, one instruction I have received that on 15/9/22, authorities asked him to submit a item-wise claim list for.
Will not go to that. If you want to file an affidavit as regards jurisdiction, maintainability, arbitrability, will answer it. Or if you say no, it can be he has not filed, it's good for you.
Lordship, and then I am praying for.
Okay,
something.
MSB Sharma, net counsel appearing for the respondent, press for is granted.
4 weeks.
Weeks have already 7.
2 weeks time. You will give us, you get an adjournment, 2 weeks time to file affidavit.
Apply.
My lord, in this case,
So a similar order has been passed by a coordinate bench, Lordship,
What is the issue here?
above 20%. Claim is above.
my lord, whether he agrees to argue without a affidavit, But-
My lord.
my right will be prejudiced. What is their stand?
Okay.
Lordship, I will.
Okay, Mr. S.S. Roy, learned counsel for the respondent submits that though the case of the petitioner is also covered by the ratio laid down in the case of Messrs. ATW within bracket India Private Limited versus Union of India and another, he would like to file an affidavit in the matter. Full stop. The Mr. Hussain, learned counsel for the petitioner, however, submits that the present petition may not be covered by the aforesaid decision.
Yes, yes, because fact is different.
Fact is different. Okay, that is okay. Accordingly, matter stands adjourned to enable Mr. S.S. Roy to file affidavit list after 2 weeks.
Obliged.
May I please, Lord?
Mm.
Matter pertaining to forest royalty, my lord, law is, regarding realization of forest royalty, my lord. My lord, law is well set on, in fact, your lordship has passed the latest judgment, my lord. RCM Construction Private Limited, my lord.
What happened now?
My lord, in this case, my lord,
Hmm.
when the petitioner submitted his running bill, he was asked to submit the forest royalty clearance certificate. He submitted the forest royalty clearance certificate because he paid the forest royalty before the Mizoram government. Then the authority verified the same, my lord. From the Mizoram government. Mizoram government confirmed the same, my lord. Till, my lord, his 30 lakh has been withheld, my lord, by the authorities, my lord.
Now, what is this affidavit?
Affidavit filed by me yesterday, my lord. There is nothing, it was only just the citation has been referred, my lord.
What is their stand?
Their stand,
Lordship, what they have contended is that the materials were brought from Mizoram. And with Mizoram, there are only 2 checkpoints, which is manned by Forest Department. There are no records to show that those producers were brought.
What the mandate of RCN? Is there any clause in the contract?
Here, as per this agreement annexed here, it looks incomplete in the petition, but even otherwise, Lordship, there are statutory provisions allowing state to deduct royalty from governmental work, Lordship.
That has been laid down in this code in RCN. All the conditions, pros and cons are explained, saying that you can do under these circumstances.
Yes, statutory provision, because Muslim Ali judgment, it says either it can be incorporated in contract or there might be statutory provisions, Lordship. The statutory provisions are very clear, Lordship. The state government is.
Which is the statutory power? Have you gone through RCN?
RCL judgment I have not done.
Then why are you arguing?
Because
that statutory provision was argued that when there is under Assam forest regulation, isn't it?
Yes.
Or what statutory provision are you saying?
I'm referring to Lordship AMMC rules 2013.
No, that has been dealt with in the RCN, not only AMMC rules, Assam forest regulation for collection of revenues. And that has been answered. That even forest regulation is not applicable until and unless it is a specific permission is given by the forest. It is not for the others.
Then Lordship may grant me some time because here the agreement annexed in this petition.
Your case is that your case is covered by RCN.
Yes, my lord.
And they will verify in terms of RCN whether there is agreement or not. So you want a disposal in terms of RCN.
Yes, my lord.
And you say that there are statutory provisions.
Yes.
And you have not read RCN.
Lordship may grant me some time to.
Okay, learned on the prayer of the learned counsel for the respondent, matter stands adjourned and be listed after a week.
My lord, matter is treated as part hard matter.
What part hard is?
My lord,
It's a similar matters. What part hard?
My lord, everything is clear, my lord. I have gone through all judgment, Muslim, and in one judgment, my lord, I have, in fact, that judgment was not considered before by your lordship in the RCN, my lord. One Deepayan Pal, my lord.
I've seen that. I've seen. So what is to be hard?
Yes, my lord, nothing.
If nothing is to be hard, how can it be a part hard? Yes, next case.
Date may be fixed, my lord.
Date, you make a mention on Monday before that. I'm not taking up this bench. I don't want to burden the other court by fixing dates. Yes. Who will pay the contractor's bill?
Last of they supposed to file the affidavit. There is the order dated 2/2/2024.
What is the cause list? This is item number
31.
What is this construction?
This is the temporary measurement for third semester. In the immediate measures to third semester, restoration of Samulbari and its adjoining areas under the Sondapur Revenue Circle of River Brahmaputra under LTR for the year 1890. Work is completed as per expectation. The executing agency loss in the water research department filed the affidavit loss.
Who is for this deputy commissioner? And Mr. Doctor, what is this evasive affidavit?
We have not. What are
Yes, Assistant Chief Engineer water issue. Yes, what is this your evasive affidavit? Your case is that you have monitored the, only you have no responsibility to make payment.
Yes.
Very good. This has been done by the Deputy Commissioner. Payment is to be made by the Deputy Commissioner. But admittedly, work was executed under your supervision.
Yes.
So whether they have executed the work properly, whether bills they have submitted are actually due to them, who will certify? Deputy Commissioner will pay a bill because Deputy Commissioner said, see, this is my money. Immediately there is a need for flood damage and something like SDRF. So these are the money meant, money is there. You get it executed through one of your contractors. Money is with me. Now you get it executed admittedly through him. Is it not your responsibility to make a statement in this affidavit saying that no, he has not done the work properly, so therefore he is entitled for this much amount? Or that no, we have awarded his, we have monitored, he has done it very nicely, and he has this bill amount, though he has claimed 2 lakhs, he is entitled for 1,88,000. Then only we can get hold of Deputy Commissioner.
We have submitted the work completion certificate and everything.
Where is that statement in affidavit?
Paragraph 7. Last part of the work completion report for payment to the petitioner was submitted to the Deputy Commissioner Kamrup Metro by the Executive Engineer via office letter.
So, do you say that this work was properly completed and money, you have verified his bills?
That you have not stated.
That is what is needed. Why people are litigating in this court? And we are deciding all this till for 340. Had it been an affidavit that this is the stand, they have executed, we have asked the Deputy Commissioner that bill is given, why don't you pay? Deputy Commissioner will not say that, oh, he has done it, I'll release the bill. Deputy Commissioner, again, I'll ask you, please give me the details, whether properly done. Deputy Commissioner will not verify. He will depend upon you.
We have submitted
The petitioner. Yes, Deputy Commissioner. Go.
Certified by them.
Huh?
Bill certified by the water resource department. I have annexed the bill.
Annex the bills.
That case,
What is their statement as regards the bills?
I have only annexed that I have completed the work.
Kogoi.
I will to obtain, sir.
Okay. See, we can pass a direction,
Loss.
verify and all. Ultimately, again, a contempt.
Loss.
Of course, that may be good for a lawyer. The present petition is filed. Mr. K. Gogoi, learned counsel for the learned counsel representing respondent number 3. Respondent number 3. Oh, no, the Deputy Commissioner.
Deputy 6.
Deputy respondent number 6 is that he may be granted some more time to obtain instruction regarding the reason of non-payment of the non-payment of the bill as claimed by the petitioner, in as much as the respondent number 3 has already filed an affidavit admitting the execution of the work by the petitioner, under whose supervision the execution was done. First of list this matter after 10 days. Gogoi, registered to list this matter showing name of K. Gogoi.
This is regarding the earnest money.
Hmm?
Here the petitioner has executed 3 works.
Hmm.
The petitioner deposited earnest money.
Then
Not
bill you have got.
no, my. For that, the petitioner filed a writ petition before this honorable court.
Where is the, what happened to that?
That is a disposal by the honorable court. Directed the respondent authority to pay the outstanding.
Where is that order? Yes,
Madam,
why
that is-
earnest
that-
money is
now
not,
This is on the contempt.
what, why? Mr. Rava, yes,
My lord,
who will give this
My
money?
lord, in this case, my lord, petitioner has not completed the work, my lord.
Huh?
Earnest money is released only on completion of the work, my work,
Ah.
my lord. My lord, in this case, he has not completed his work, my lord.
Where is your affidavit?
Yes, I will find.
Who are you?
I am.
Correspondent number?
Correspondent number.
Here the BGC is the main party.
No, no, who, under whom you have executed the
I am applying for respondent number.
respondent number?
Irrigation department, your
Huh?
irrigation department, respondent number 114.
Respondent number?
14.
Who are they?
Respondent number 1 is here.
1 and 4.
Irrigation?
Yes,
Under, by you, under you work has been executed.
yes, my lord. As per instruction, but he has not completed the work, my lord.
Okay, learned counsel appearing for respondent number 1 and 3.
1 and 4.
1 and 4.
No, not 3, my lord. Only
1 and 4.
I am for.
Commissioner and Secretary Irrigation and Executive Engineer Irrigation BTC.
Yes.
Isn't it?
I am for the BTC.
Yes, well, I am
2,
only for
3 and
1.
4.
I am only for 1.
How are you related to the work?
Yes, sir.
This is a transferred subject.
It is only the response.
Yes, I have its instructions, my lord.
Hand over the instruction to. Because this is not executed
Yes.
under you,
Yes, your lord.
isn't it?
Yes, your lord.
This is a transferred subject.
Let the instruction given to me,
Yes,
my lord.
Rava, file an affidavit.
Yes, my lord.
Okay, Mr. S.R. Rava, learned counsel for the respondent number 2, 3 and 4. Press for further 2 weeks time to file affidavit. Prayer is allowed, list according.
With your-
36 also same.
36 same.
Same.
Yeah, I-
Probably.
Make little.
Yes.
But we have supplied certain items. 37 Lordship, otherwise our activity is ready, Lordship.
Mm.
We have, as per our Lordship, our instruction, Lordship, almost the claim amount we have given, Lordship. Only he says that 1 lakh is Lordship, so.
1 lakh.
1 lakh. Otherwise, Lordship, out of his claim of 80,75,225. And we have paid him, Lordship, almost 80,05,100, Lordship. Our affidavit is there, we will pay. After 10 days. After 10 days.
We also paid for interest.
Interest, he has to go civil court, Lordship. He has to go civil court, Lordship.
Take the money and then your cause of action will start at interest.
Almost all.
Mr. Gogoi, K. Gogoi, learned counsel submits that the affidavit is ready and same could be filed within a period of 10 days from today. First, accordingly, press for an adjournment. Prayer is allowed, list after 2 weeks.
May I look?
Yes.
The order dated 18/12/2022.
Order dated?
18/12/2022.
Lordship, we have received instruction, Lordship, it is forwarded to the higher authority. On the basis of that also, Lordship may.
Who are you? Mr. Gogoi?
Lordship, all are respondent for.
Heard Mr. Kanikar, learned counsel for the petitioner, also heard Mr. K. Gogoi, learned additional senior government advocate, Assam.
For Lordship, yes, number 1, 2, 3 and 5, Lord.
1, 2, 3 and 5, and Mr. A. Saliha, learned standing counsel for the finance department for the respondent number 4. Agree by non-disbursal of 2 bills amounting to rupees 367,481 and 371,519, totaling rupees 739,000, in respect of hiring of vehicles by the respondent authorities, more particularly, the respondent number 3 for the period with effect from 1/1/2016 to 36/2016 and from 1/7/2016 to 31/12/2016 respectively, the petitioner has approached this court by this writ petition. Mr. K. Gogoi, Learned Counsel, on receipt of written instruction, has submitted that the Deputy Commissioner of Police, within bracket administration, ADMN, by its communication dated 22/12/23, has already reported the non-disbursal to the Deputy Commissioner of Police Crime, Guwahati, Assam, requesting to accord sanction of the fund of an amount of rupees 739,000 to make payment of the same to the petitioner. Full stop. In view of the aforesaid, Mr. Gogoi further submits that he has received instruction that without sanction and allotment of the fund, the amount due cannot be paid, and such sanction has yet to be received from the competent authority. That is who will give the sanction, Mr. Salian?
It's by the.
It is by the Deputy Commissioner of Police Crime.
Sanctioned by the Lordship DGP office.
Shall be sanctioned by the office of the Director General of Police.
Lordship.
Full stop. Any Director General is a party?
Party.
Okay. Mr. Gogoi has also produced the communication dated 22/12/2023 issued by the Deputy Commissioner of Police, within bracket administration, to the Deputy Commissioner of Police Crime, and instructions given to him by the Deputy Police Commissioner Crime. Accordingly, same are kept on record and marked as document X. In view of the aforesaid clear admission, the present writ petition is disposed of, directing the Director General of Police, Assam, to verify the claim of the petitioner as well as the report of the Deputy Commissioner of Police Administration, and if it is found that the petitioner is entitled to the aforesaid amount of rupees 73,900,100, same be paid, full stop. The entire exercise be carried out within a period of 3 months from receipt of a order of this, receipt of a copy of this order passed by this court to be furnished by the petitioner before the Director General of Police, Assam. Writ petition stands disposed of. You can take a Xerox copy if you need. Yes.
My lord, there is a pendency of this petition, my lord. One order has been passed, my lord, granting my lord, relief to the petitioner. Whereby, my lord, my work order was cancelled. This impugn order is already cancelled by the engineer.
Okay. The present writ petition is filed.
Being aggrieved with the my lord, page 45 order.
Page 45. The present writ petition is filed assailing an order dated 15th of July 2023, whereby the work order for the work of Phubandhar, BHU, BA and DHR, page 45. Phubandhar, capital FIS. Construction of so-and-so silo pencil dark dish. Work order so-and-so issued in favor of the petitioner was cancelled.
My lord, the same has been revoked now, my lord.
Cancelled. Full stop. It is submitted by the petitioner that during pendency of this writ petition, said cancellation order has been revoked by the respondents. Accordingly, it is submitted by the counsel for the petitioner that no survive cause of action is there to pursue this writ petition. In view of that, this writ petition stands closed, being in first phase.
Sir, my name may be recorded.
MS,
DS new, my lord.
DS,
New
now
for
for
irrigation department.
the irrigation department. Upor diba hard Mr. So and Mr. and Salia for finance.
Deeply obliged.
Yes.
My lord, this is also regarding my lord non-payment of contract for bill, my lord. But I am praying, my lord, as per Tamser Ali.
My lord,
Not answer early until and unless there is an affidavit.
my lord,
My lord.
may grant 2 weeks time to find.
You are appearing for?
IWT on behalf of MD Bora.
Okay, you are?
S Bora.
Okay, learned counsel for the IWT press for and is granted 2 weeks time to file affidavit.
Obliged.
Dispose of? Dispose of?
I have seen.
Heard Mr.
Arborua.
Arborua.
So only one thing is just.
We'll just record your name first. Arborua and Mr. D. Nath Larned, Senior Government Advocate. The petitioner claims that, what is the order? Earlier judgment.
My lord, page number 74.
74 it starts.
So start then.
Is the petitioners, how many petitioners?
My lord.
More than one?
More than.
In your case?
My lord, my lord.
The petitioners are the Gram Panchayat Samabai Samitis / cooperative societies
22.
of the district of Tinsukia. The petitioners are societies registered under some Cooperative Societies Act 1949 and are regulated by the aforesaid statute and the rules from thereunder. The petitioner societies are in the field of lifting and distribution of PDS article under the Essential Commodities Act 1955 and also the Assam Public Distribution of Articles Order 1982. Okay. The claim of the petitioners are that they are not being paid their due by the
Page
40 due by the due against their commission due to them. Page 40 against the commission due to them. Due to them. Full stop. Due to them. According to the petitioner, such amount is to be paid by the state from central assistance. Isn't it? Central assistance in terms of the National Food Security Act 2013. Okay. They claim that similarly situated cooperative societies on non-payment of commission for distributing food grains / rations had approached this court by filing different writ petition, and this court by its and common order passed in IAS Civil /139/2020 arising out of different writ petitions issued certain directions for payment of such outstanding due. The petitioner submits that being similarly situated, the petitioners also entitled for similar relief. Mr. D. Nath, learned senior government advocate, on instruction submits that. Now, what is your problem? Tell us.
Para 18
Para 18 of the judgment?
Of the judgment, and para 18 and 19.
18 and 19.
18 and 19, page 79. This is the pursuant to a decision of the government of Assam in 2016. In 15, it was given out of 143 rupees, 70% for the shop, 30% for the cooperative society. It was contrary to a decision of the central government. It was the decision taken by the government of Assam. Ultimately, when the central government has noted that, it was rectified by the government in the year 2000, subsequently in 2020, and we have stopped that. At that point of time, till it come to para 19.
Para 19.
In that bank account, some unspent amount was there, and that was cleared. That was cleared by this order. But now there is no fund in that particular time. So, two things.
How will you pay then?
That is one, and the second thing, of course, we will verify how much they have done or what is their entitlement for the period from April 2020 to November 2020. That is the period. They are also claiming that only, that verification can be done by us, but that particular unspent amount has already been given, and in 2022, now
there is no man. Okay.
No man.
Okay. Come on, Mr.
Para 19. That kindly,
No, we'll see what is the direction.
At that point of time, because of that, unspent money was there. The learned AG has given an undertaking that it will be cleared to them.
But ultimately, you do not dispute that this is due to them.
As per the decision of the government at that point of time, they work and they are similarly situated.
Though Mr. D. Nath, learned senior government advocate, has not disputed as regards execution of the on instruction, has not disputed as regards execution of the petitioner, execution of the work by the petitioner. However, he submits that, listen to me, however, he submits that exact amount due to each of the individuals can be verified by the competent authorities only. He further submits that though the case of the petitioner is squarely covered by the earlier order that has been relied on by the petitioner, however, at that point of time, funds were available for
para 19,
as reflected in para 18 and 19, of the aforesaid judgment / order, aforesaid orders, not judgment, it was order, aforesaid order. However, it may require some time to arrange for money for those petitioners, as the amount of money as recorded in paragraph 18 and 19 has already been spent in payment to the earlier petitioners. This is the situation. Has already been
to the society.
Spent for payment of money due to the similarly situated cooperative society. As there is no dispute as regards the due claimed by the petitioner in terms of the order dated or paragraph 18 and 19 of the order passed by this court in IAS Civil 139 of 2022, and also there is no dispute as regarding entitlement of money to the petitioner, in the considered opinion of this court, the petitioner cannot be deprived of their right for want of fund at this stage. Accordingly, it is provided that we'll give a time. Accordingly, it is provided that the petitioner shall approach whom, before whom, who will pay.
My lord, page number 82 is the on the after receiving the order. My lord, he released the fund, my lord.
Who will pay you? Generally, who pays you?
My lord,
Commissioner, he only releases the.
He releases.
Only ultimately it is the department, my lord. Ultimately the
director.
now director has been redesignated as commissioner.
Commissioner of?
Commissioner of Food, Civil Supplies,
Okay.
Consumer Affairs and Legal Matters.
File a representation before the Commissioner of Food and Commissioner and Secretary.
No.
Commissioner?
Directorate has been redesignated as Commissioner of Food, Civil Supplies, Consumer Affairs and Legal Matters. Now everything-
Submit a
Earlier director,
representation
kindly say
with their individual claim. Huh? With their individual claim before the Commissioner
Food, Civil Supplies and
whose
Consumer
food, civil supplies and consumer affairs
Affairs and Legal Matters.
and legal meteorology.
One.
Meteorology 1.
Earlier director.
Okay, within a period of
my lord, 15 days.
within a period of 15 days from today, on receipt of such claim along with copy of order passed today, the Commissioner shall do the needful for arranging the Commissioner shall verify the individual claim, and after ascertaining such individual claim, the said Commissioner shall do the needful for arranging the finance if necessary by involving the Commissioner, Finance Department, and thereafter release the fund to the concerned Deputy Commissioner.
Thereafter do the needful for release.
Thereafter do the needful for release of the admitted amount to the petitioners. The entire exercise be carried out within a period of
2 months is short.
3 months.
4 months maybe.
4 months. Let us 4 months. Let us not go for a contempt. But don't within a period of 4 months from date of receipt of a certified copy of this order and the claim submitted by the petitioner. But you file the individual claim because they will have to see individual.
Ultimately, supporting documents are
With their supporting documents. I'll just fine tune this order later on. Yes.
Similarly, CPA position is admitted.
But understand.
Individual.
They have done it, but they would have got it at that point if they would have come at that point of time. In the meantime, you spend the money. There is for your mistake that mess is committed. Ultimately, they have executed their role. Disposal. This is item number?
Production 1. Production.
Okay. Yes, madam, we'll do your, you suffer a little bit more, okay? Today may not be possible to dictate the order. We'll pass or give a date for delivery of orders. No further hearing. More or less we are thinking of with some observation. Yes. Yes, what is this?
May it please your lordship. I'm for a petitioner. I'm sorry, my lord, I was not there yesterday.
No issue, no issue. Yes.
Because of some personal difficulty, I could not be there.
No issue.
My lord, I'll just give a brief idea about the case, what happened in this. It's a fix for hearing now. This is an employment state insurance recovery which has been done against the petitioner. The ESI Corporation has recovered the amount, stating that we have not registered ourselves in the ESI and we have not paid the amount, which was requisite amount to be paid to the ESI. Now, the question which is arising here is the hotel industry. The first petition is with relation to the hotel industry.
Okay.
And the third is also the same Radha International. In first
Just
petition,
a minute. I can.
it's 4139 is the first one, 4139 of 2014.
Just a minute. This is hearing matter, no?
Yes, madam.
Where is that list? Huh? What, carrying a list? Huh? Okay.
It's coming in the supplementary list, my lord.
Okay. So, item 54
Yes, my lord.
and both are same, identical, 54 and 56. Why two repetition?
Because in the first one, they have recovered the amount with relation to ESI. In the second one, they have collected the damage for not paying the ESI.
Okay,
Which
so
happened subsequently.
both these cases, they have already recovered.
In all the three matters, otherwise they have recovered.
Okay. So therefore, you want a refund of those,
Refund of the amount.
refund of the
Recovery
amount.
also surgery for setting
For
aside
setting aside.
recover.
Setting aside their decision so that you are first will have to set aside. And
Please.
what about 55?
55 is not hotel industry, it's a distillery. But there also we are questioning the procedural part where they have raised
So far relating to Gemini, it's a procedural part.
Yes,
So far relating to Radha, even non-applicability of that.
No, in Radha International, I'm saying that ESI Act is not even applicable.
That is what?
Yes,
So
yes,
there
ma'am.
is no non-applicability in case of
Non-applicability.
Radha and
Absolutely
in
without
case of
jurisdiction.
procedural lapse.
Yes, my lord.
Okay.
So, my lord, in Radha International, the hotel has fallen under the ESI category in the year of 2010.
Okay.
And at that time also, the total number of required employees was 20. Subsequently, in 2011, the number has been decreased to 10.
Okay.
But the so-called notice as well as the recovery notice which has been issued against me was of 2009.
Okay.
So 2009, hotel industry was not even falling under the ESI category. Secondly, they are trying to say that hotel
What is the amount? What is the amount?
It will be around 3,84,000 in the first one. Then almost 5 lakhs.
Okay.
Approximately 5 lakhs in the Radha International. In the Gemini Distillery, it is approximately around 10 lakhs.
These hotels situated where?
These are situated in Tripura.
Now,
Yes,
why this High Court?
that question will arise. In fact, that's a preliminary objection raised by the respondent also. This recovery officer was from Guwahati, who has issued the recovery notice. And the ESI office, the cause of action in that case is arising in Guwahati because the recovery officer has recovered all the amount. He has issued all the direction to the banks from the Guwahati office. And ESI Corporation, the regional head office is in Guwahati. So that way, in fact, the entire jurisdiction for the northeastern region, the Guwahati office has the main jurisdiction. And those are the Tripura and others are the branches. So that way, even under 226(1) and 226(2) cause of action, both way it is covered. And that is why my lord has a jurisdiction.
Okay.
My lords. May I proceed?
Okay, proceed.
Yes, sir. So that's the entire.
You are ready?
That's the preliminary issue that hotel otherwise is not falling under the ESI Act by till the 2010. And now they're in the affidavit, they are saying that hotel falls under the manufacturing unit. Admittedly, in their own notification, they have included hotel in 2010. Now they cannot say that fooding and lodging.
So this amount recovered is period for which period?
For 2009 to 2013.
2009 to 2013.
One so-called notice from one recovery order. It is not that it has been.
So therefore, your first contention would be,
yes, sir.
When hotel industry was not within the ambit of the act itself till at least 2010.
Please.
2009-10 is absolutely without jurisdiction.
Absolutely without jurisdiction. And second,
so far relating to the subsequent period, what was the number of employees?
For subsequent period also, my lord, we have written to them that we had less than 10 employees. They are saying that they have done an inquiry and after verification, they have come out with the number 11. Now, when the inquiry was taken place, it was in the, admittedly, in their affidavit, they are saying that December
prior to
absolutely, my lord, in December 2008, After 5 years, they issued a so-called notice and said that you have 11 number of employees. I stated specifically I didn't have the employees. And now what they have done? They have hold a meeting. They said that you register yourself in the ESI. You write to us. The Labor Commissioner said we will exempt you. We have registered ourselves. They did not give out any exemption. They seized all our bank account and recovered the money. And in the affidavit, they are saying that no, you should have written to the government of Tripura, not to the Labor Commissioner, which was their manager meeting where they are saying that you write to the Labor Commissioner and the ESI, we will think about it. And subsequently, they recovered all the amount by pressurizing us. And now in the affidavit, they are saying that you have not written to the government. That's why there was no scope of exemption.
Okay, so will you be able to conclude today?
My lord, in showing the pages, of course, it will take some time.
Take some time.
Otherwise, we had a great discussion on that.
When do you propose to do? I
My
will
lord,
be partially.
that is one request, my lord. Next 2-3 weeks, there is a problem with me. If it can be after 3 weeks, my lord.
Give a date, propose a date.
Yes,
because
my lord.
these matters are scar on us, 2014.
Absolutely, I understand, my lord. It should have been, I should have appeared yesterday only because of some personal difficulty. I
No,
couldn't.
your physical appearance we may not insist, but
Yes, my lord. Yes, my lord.
so today, due to paucity of time, we'll have to adjourn. But we'll do this matter, give a date.
Any Thursday, ma'am, my lord, it can be on 21st of March.
21st of March. Okay.
That will be hearing day one.
So whatever you want to give some judgments or something like that, whatever,
Yes, ma'am. Yes, ma'am.
you can give the day prior.
Yes,
or
ma'am.
on that day also, no problem on that, but we should be your colleague is here. Okay.
Yes, ma'am. I will submit the
Of course,
judgment.
we'll welcome you if you physically here. That is
My
not
lord, I would also love to be there in physical mode. I'll try my best.
okay. So your affidavits are complete.
My lord.
Are you having the record?
My lord, record evidence. So we are issuing the question of jurisdiction as
Will you? So therefore, on the next date, you first raise the point of jurisdiction
and maintainability.
and maintainability. Okay. So
Yes, ma'am.
then first we'll hear them on 21st as regards maintainability and jurisdiction.
Yes,
If we accept, then we'll not proceed. If we say that no, these are rejected, then we'll proceed on merit. Okay.
Absolutely, my lord.
Okay. Hard.
Case only.
At some length, please this matter for further hearing on 21.
Yes.
We'll here we have kept it as a partner because
Yes,
otherwise again it will go to a different bench again. 2014 matter will finish.
My lord, please, oblige.
Why maintaining jurisdiction point? We understand why have you raised it?
And also, these are disputed question of facts. As per section 75 of the Act, the ESI court is a proper forum to educate these matters. And this court over time, over the years, have referred the matter to the Act.
Okay, so
It also
your
should be-
basic objection as regards maintainability
and jurisdiction.
Maintainability on the point of jurisdiction and maintainability on the point of alternative remedy.
Alternative statutory provision. As also.
Okay, you also so he's more
I
or
also
less.
the judgment. Alternative remedy, my lord knows that there are many without jurisdiction. If it is without jurisdiction.
I'll also show the judgment. Apex judgment is also here regarding EI court.
Yes, if possible, you give the judgment day prior to the fix. Okay.
My lord.
In the morning hours, so that we can.
Well, I have the.
You can have the mail and give the citation, or you can give to.
Yes, yes, my learned friend is there. I will give it to him.
So we'll not waste too much of time.
My lord.
If we overrule that, then we'll proceed to the merit. And if we'll accept, then matter ends there.
Yes, ma'am. Absolutely.
Okay.
He tried to be good. He tried to be good. টেষ্টৰ লগত সোমাই মই ছাৰক সুধি লওঁ সুধি পেলাই কৈ আছো ফেক্টৰী ক'লে না মই লিখি দিলো কিন্তু ডেলিভাৰী প্ৰডাক্ট পাইছো ৰিকুৱেষ্টটো
এই কি দীঘলীয়া চিটুৱেশ্যন নেকি? হা? কি বা? আপোনালোকৰ কি হৈ আছে? টিভি? হৈ আছে? কাটি লৈ যাব। কিবা প্ৰব্লেম হৈ আছে, গম পাইছা? আপোনালোকে কেতিয়াবা কাটিম, নাই হৈছে।